My lord, one matter pertains to my lord, Honorable Justice Shubha. So, मुझे तो lord
Chamber matter.
No matter. As one leave is required for 1 day delay in filing.
Mention when I sit in court after the chamber matters.
Three application in chamber.
Yes.
Your Lordship, may I permit to mention the matter? This is pertaining to Marshal House agreement and several applications pending before Your Lordship.
Matter is required to be what? Contested. Matter is to be heard out.
Yes, Your Lordship. Now, Your Lordship, there are 15 other applicants who are also sub-suppliers. Kindly allow to take leave for the 15 applicants and fix this matter any day next week, convenient to Your Lordship.
It will be taken up after vacation if there is no urgency.
Yes, Your
File
Lordship.
it, you file it.
Kindly
You file it and thereafter mention, it will be considered.
application you have taken and you have taken this matter and you have grant stay also those matters.
No, you file it, thereafter you mention. Okay.
Also, may I permit it to mention for inclusion?
Yes.
লর্ডশিপ মামলা আজ পর্যন্ত আসেনি লর্ডশিপ, যাতে আসে প্রার্থনা জানাচ্ছি। লর্ডশিপের কাছে প্রার্থনা লর্ডশিপ, আগামীকাল লর্ডশিপের দয়া বলবো।
Item number 1, Piyush Bhatia.
I appeal on behalf of the decree holder. The matter has been settled. The terms of settlement, Your Lordship, is proper.
Yes. Terms of settlement. Terms of settlement between the decree holder and the
Decree
judgment.
holder and the judgment debtor. Page 2 onwards, the terms are enumerated.
Okay.
Lordship will just, I apologize for interjecting. Your Lordship will just kindly take up page 4, paragraph 4 once. Lordship will notice that it's 11 post-dated checks that's proffered. Lordship will just kindly, if it so commences to your Lordship, will just kindly consider making it outlaw of list instead of disposing of the matter.
No, I'm keeping it after 2 months
Lordship,
or something like that.
very grateful.
Learned advocate for the degree holder and learned advocate for the judgment debtors are present. Terms of settlement is filed, which is entered into between the degree holder and the judgment debtor. Let the terms of settlement file be kept with the record as the prayer is made for adjournment, so that the report may be submitted as to the result of the terms of settlement. The matter stands adjourned till 15/7/2025.
Grateful. Grateful, sir.
Chamber application item number 2.
My lord, I am for the applicant. My lord, this is the application for substitution in connection with a partition suit. My lord. And the defendant number 5 passed away on 1st April 1970.
You are the heirs of the defendant.
My lord. I am the heirs and this is the partition suit. And although it
Mr.
was...
Lahiri is representing whom?
6 CBLC.
Defendant number?
although it was the knowledge of the plaintiff about the date of the defendant number 5, because that
Who is for the plaintiff?
no, my lord, I have served. Plaintiff number 2 has received. Second time I have sent the notice, but in spite of that, no one has
Applicant.
appeared.
There is
Yes.
no
My-
prayer for setting aside abatement.
No, my lord, question of this is a partition suit, and I am placing the copy of the citation. And my lord, it was that Honorable Justice Bibhash Patnaik directed the
No, he will
department to
enter into
produce the
the-
record.
Come into the picture, whether it is abated or not, it is for the plaintiff to come and file setting aside
My
abatement.
lord, I am placing this.
No, but how can they be substituted when it died?
No, question is,
Number one. Number two, they are all Christians.
No question of this. No question of this arise in these circumstances.
They cannot be substituted.
It cannot be arise.
They are all Christians.
No substitution in the case of an
No, do you want to file-
partition suit.
are you
I
observed?
file.
Yes,
Hello,
while
sir,
making
what is-
false statement that substitution application was heard but there was no substitution application was filed.
No, we have not said that. We
My
have-
lord, it will be reversed from the record.
Anyway, what is your objection? Please let me know.
My objection.
His objection is that they are Christian.
Anyway,
There is
let
no
me
proof.
let
There
me
is
see
no
the-
proof. I am placing the copy of the citation, my lord, one. And the order of the Honorable Justice Bibhash Patnaik to produce the records, and perhaps record has come. And my lord, my respectful submission is this: if it is paragraph 9 is very important. It is applicable. In my case, I think so.
A substitution of this defendant has never happened.
No, my lord, it can be reversed from the record if it is reversed from the record that no substitution application was filed and they are not substituted.
When did this person die? When did this defendant die?
Died
First
1st
April
April
1971.
1971. আমাকে-
1st April 1971.
And my lord, that date was informed to lawyer, but he has not filed any
Foot of
substitution.
1968. 71 it was filed. 71 this defendant died.
My lord. I have annexed the death certificate also. It was informed by his widow to her lawyer, but unfortunately no substitution application was filed, and it was their assumption that substitution application was filed. So when they came to know the legal heirs of the Indian number 5, that now substitution, they came to know only the end of the 23. And then they filed, because in spite of knowledge of the plaintiff, so many years have passed, they have not taken any steps for filing the substitution application. And my lord, if it is reversed from the record that no substitution application has filed, I am praying this application may be allowed, because it is connected with the partition suit.
Kindly takes the prayer of the master summons. By setting aside our abatement.
No question of this. No question of
71
this
died.
party.
Why? Well, widow died long back. So it has-
Widow died.
there is no prayer for setting aside our abatement.
No question of this.
71 died, suit abated. Who are the defendants?
This is the partition suit.
Even if it's the partition.
It is the partition suit, and order 1 rule 10, this court has ample power to add the parties, either plaintiff or defendant.
Then this is not an application for addition of party.
Why addition of party? No question of this.
Anyway, you have made your contention in your affidavit.
And I filed my affidavit.
And
my
that
affidavit
making a
kindly takes
wrong
paragraph-
statement that
Affidavit statement.
substitution
I-
application has filed.
No,
But my lord, it will reverse
Yes,
from
which
the
page, which paragraph?
kindly sees. my
no
affidavit.
order, copy of the order
Arre
is
Baba.
annexed.
Anyway, yes.
Kindly sees paragraph 3.
Paragraph 3.
I said that the carriage of proceeding is with the plaintiff. Duty of the applicant to intimate date of her parents to the plaintiff. Now, record 24, Amarnath Mollik was defendant number 5. HON'BLE. I say it was duly substituted, but from the records
No.
I find he was not substituted.
They are not substituted.
Madam, please.
Please let him submit. Yes,
Because all the applications thereafter
in
were
the case of the applicant that this defendant died in the year
71.
1971 and thereafter his widow also died.
Yes,
We
we also
died.
died.
Yes.
Now, no substitution application was filed by the plaintiff because
What is your relationship with the
son and daughter.
Son and daughters,
Son and
they are now major.
Okay.
Son and daughter.
Yes.
Now, through all out the applications were been taken out, their names appeared in those applications.
No.
Madam, please let me, I'm trying to help you out also. But when the matter came up before Justice Bhatnagar directed both the parties to look into the records to find out from the plaintiff if substitution ever happened or not. We checked the plaintiff, substitution of defendant number 5 never happened. Now, this is a suit for partition,
Right.
number 1. Number 2, carriage of proceeding is the plaintiff has not done. Now, the heirs of defendant number 5 has come up with this application. The master summons does not say setting aside of abatement. Number 1. Number 2, we have stated that in paragraph E, that Amula Mullik as well as son and daughter, Tapon Mullik and Nena convert to Christianity as per information gathered by the defendant. And upon death of
Yes.
Amula
Now the
Mullik,
question of law is without setting aside abatement whether the court can
Yes,
pass any
yes,
order or not. This is the question of law.
Yes. one prayer would have been sufficient. Because even if defendant can file this application,
Because they are also
they are also
interested in the suit property.
all plaintiffs are defendant, all defendants are plaintiff in a partition.
So the
without
question
the
is
prayer-
unless the abatement is set aside, whether the court is empowered to proceed with the suit at all or not.
No, it will be qua the defendant number 5, the suit will not proceed. A decree has been passed. Final,
Only preliminary decree.
Preliminary decree has been passed.
Yes. Final decree is awaited.
Well, if it is
Preliminary dates took place prior to the
Prior to preliminary decree
preliminary degree. Anyway, the preliminary degree is passed.
passed. Shares are determined.
Okay, now the final degree is to be
Final
passed.
decree passed. Final decree, there were orders. There is a receiver appointed.
Okay, now she wants to, this legal layers of this defendant wants to come into the picture.
My simple prayer would be that upon setting aside of abatement, it can be allowed, but no prayer of setting aside. And they should be added as Christians and not as Hindus.
Christian, my lord, doesn't
And they have not
arise,
given
my
any
lord.
proof.
My lord,
In
I am
their
praying,
reply,
my lord.
in
My
their,
lord,
they
I
have
am,
said that they are
I am
Christians.
praying.
Have you disputed their relationship with the heirs?
No, we have not disputed. We have said that they are
No, my
Christians.
lord, I am
firstly.
praying one thing is this.
And they have not denied in their
My
reply.
lord, I am praying one thing is this. If it is allowed, nobody will prejudice. This is the partition suit. The plaintiff and defendant has right.
The shares of the deceased defendant is also determined.
Yes,
My
yes.
lord, one thing is it is
They
not
are
affirmed.
entitled to those shares.
Don't know what is the position of the suit. Only for this, I prayed before your lordship that as this application is, no one appeared on behalf of the plaintiff. Only I have heard
Even
and
one
my
plaintiff is also done.
Shares are declared.
Yes, yes.
my lord, there is we don't know actually whether shares are declared or not. What is the proof? Only the
Records will speak for itself.
Yes.
I don't know because no copy is with me. আমাকে একটা copy দেবেন।
এর একটাই কপি আছে এটা পরে আমি কপি করে দিয়ে দেবো রেকর্ডে আছে দেখুন শেয়ার
So my lord, I am praying.
না এটা ডিগ্রি প্রিলিমিনারি ডিগ্রি হয়েছে
Preliminary decree copy কিন্তু shares are not declared.
Preliminary degree that is in September 24, 1970. 71 the
Yes,
deceased the defendant died.
later than after that.
Okay, learned advocate for the applicant.
Photocopy and give it.
Yes, yes,
I have only one copy.
it's better
It's the photocopy করে দিই।
learned advocate for the applicant and learned advocate for defendant number 6C are present.
PNB.
The application for substitution is taken up by this court. Heard learned advocate for the applicant and learned advocate for defendant number 6C. Hearing is concluded. Let the matter appear for orders on 23/5/2025.
I will make a copy and send.
Yes.
Employment.
It is not allowed.
আরে অর্ডারের জন্য রেখেছে 23 তারিখ
break. ये is इसका
I am appearing for the judgment day.
Oh, but this is a family matter. But I will be. I did not know Mr. Chaudhary is appearing. I have talked with Mr. Mukherjee here. I think if I talk with Mr. Chaudhary, this issue can be settled. This, my lord, I'll tell your lordship, a probate matter and a partition suit matter
Yes.
was settled together by way of a terms of settlement.
Yes, I think I have heard this matter.
Yes, yes. Your lordship had given direction for affidavits. And my lord, then what happened was, my lord, they had to sign some no objection to get certain shares from me. I had to sign certain no objection so that they can get the shares also. So, my lord, in this way, I have signed. They had also given us an no objection in an usual format drafted by the lawyers as like that we given. But when that no objection was given to SBI, whose shares were to be transferred, and the other companies, rallies, whose shares had to be transferred, then they came back. They said that now that all these shares transfer takes place through demat accounts, so there are other formalities, lot of formalities which have to be done. These existing shares have to be first transferred to the dematerialized. Then on the basis of a form which has to be given by them, those have now to be signed by them to ultimately result in the transfer. I am not complaining that they did not initially comply with their obligation, but the nature of no objection which we got is not serving the purpose. So therefore, I am requesting Mr. Chaudhary and Mr. Mukherjee, if I can say that even his advocate on record be a special officer for this purpose, we will intimate from the bank what is the nature of document on which their client's signature may be required. I will give it to the advocate on record of Mr. Chaudhary. Mr. Chaudhary's advocate on record will have it signed from his client. Whatever the bank says, I am not that I am insisting on
Now,
anything.
your grievance is this, the nature of certificates required.
Nature of no objections.
Nature of no objection certificates required.
It has to come from the bank first. The bank will specify where they have to put their signature.
Yes, did the bank submit any?
I will show your lordship one letter which has come from the bank, which,
the opposition.
if your lordship sees, there no objection which they had given. That also I have annexed. Kindly take my petition. Annexure C, if your lordship kindly takes. Mr. Mukherjee and Mr. Chaudhary, my lord, can help and have this matter resolved. This is
Or I can appoint a special officer if necessary. That can also be done.
let my lord, Mr. Chaudhary also take instruction. I think it can be.
I'll take your lordship, Lord. I'll take instructions
I
to
will
see,
just-
Lord, if it can be worked out.
To Mr. Chaudhary, what is the problem? Your lordship, kindly see page 44 of my petition.
Yes.
Kindly see, these were the no objections which my learned friend's client has given.
Yes.
From Siddhartha Chatterjee to the Shared Department, State Bank of India. This is as per our draft.
Yes.
Then, my lord, page 45. Also, my lord, other shares which were standing in the name of the wife of Siddhartha Chatterjee.
Yes.
Then 46, this is of Unit Trust of India. 47, Rallis India. 48, this is another company, Axo Nobel. So these were the no objections which we got from them.
Yes.
Then, my lord, if your lordship comes to page 49, which is the document which we received from the share consultant in respect of Rallis India. Kindly see, it is addressed to my client. Dear Sir, Madam, unit is Rallis India. So with regard to Rallis India, this was the objection which came from the share consultant. We are unable to process the request for the following reason. Please note, as per Articles of Association, where shares are held jointly, there is a surviving holder, then shares will get transferred in the name of surviving holder. SEBI has debarred physical transfer of shares since the shares will get transmitted in the name of Siddhartha Chatterjee demat to his account. Afterwards, it can be transferred to other person as per court settlement. We are therefore returning here with certificate along with respective documents and request you to resubmit the documents after removing the defect. Similar has come from the others also. I'll tell you, Lordship,
Page 50.
page 50 is thereafter. We wrote again to my learned friend's client. Now kindly see, well, first part your Lordship need not concentrate. Then kindly come to page 51, last paragraph. For my lord, your Lordship will, sorry, my lord, page 50, your Lordship will see for every share I have mentioned that what further signatures are required. Serial number 1 is with regard to a savings account. Serial number 2 is regard to SBI 40 shares held in joint names. Then next, my lord, again SBI share 100 numbers. Number 2, Rally's share 5,850 numbers. So this they are not disputing. Then I said, my lord, I shall depute my representative at your place as and when required on hearing from you. He will handle the entire share transmission bank balance transfer job in conformity to decree proceeding of the. You can, however, suggest any alternative process by which your obligation may be complied with so that transfer of title in my favor may be completed without further delay. Expenses which will be paid from my end to Mr. De. So, Lord, I said that whatever the bank or the share company requires signature, that has to be complied with. The earlier no objection is not serving the purpose. This is the only.
That is only with regard to these two companies. That is this kind of page 49 and 50. The others are okay.
No, all. In page 50 in my letter, I have mentioned about all. Kindly see page 50.
Okay, page 50.
Serial number 1 is first regarding a SB account, savings bank account. Then serial number 2 is regarding SB share 40 numbers.
Yes.
SBI share 40 numbers. This is in respect of one probate proceeding. Then in regard to the next probate proceeding, number 1 is 100 number SBI shares. Number 2 is Rally's share 5850. Number 3 is master shares 2400 with UTI. All this, my lord, is part of the terms of settlement, but the nature of form procedure which has to be followed for the transfer, that is the only issue, my lord. I am saying that whatever the bank and the company will say, that signatures have to be done. The earlier no objection is not serving the purpose. Now, my lord, whatever process my learned friends suggest, either their advocate on record will write to the bank or I will write to the bank, get the formalities, documents, make it over to advocate on record, or entire thing can be done by their advocate on record. They will have to just put their signature.
Let me hear.
Lord, may I just indicate? Lord, there are two ways of approaching this issue. One is, my lord, for a settlement. The other is, my lord, in execution of a decree. For a settlement, my lord, I completely, my lord, appreciate what Mr. Sen is saying. But a settlement is dependent on my client's, my lord, intention to settle and, my lord, not create any trouble. My lord, I'll ask him, I'll call him, I'll take instructions. I will try to persuade him to assist Mr. Sen's client. If that is possible, that is the best solution as Mr. Sen suggested. If that is not possible, and if this has to be a legal adjudication, we'll come back and make submissions. All that I'm saying is, kindly give me 2 days time. I will take instructions. If we can set.
Let us come back on Tuesday.
Yes, yes.
If my learned is there on Tuesday, let us come back on Tuesday.
Very well. Tuesday.
For the purpose of benefit of Mr. Chaudhary, I'm just intimating him that this was a part of the settlement itself.
I know, I've read it. I have also taken some initial instruction. I also speak to you tomorrow and we'll try and resolve it.
The learned counsel for the parties are present. heard Mr. Sen and Mr. Chaudhary
Huh?
appearing for the parties. As the talks of settlement are going on and necessary no objection certificates were issued by the
Judgment
by
debtor.
the judgment debtors, but the
Judgment data
same,
number one,
by judgment debtor number 1, but the same could not be implemented due to some technical
Yes.
defects. The same can be sorted out by discussions between the parties. Thus, this matter stands adjourned till 20th
Yes,
of
my lord. Grateful. 20th. Yes.
Let it
Well,
retain its position.
20th May 2000.
Yes, yes, of course.
Obliged.
Grateful to your lordship.
in opposition.
Well, let the affidavit in opposition file be kept with the record.
Obliged. I am not going to file any reply because it can be settled like this.
I appear on behalf of the plaintiff respondent.
My application, my lord. My lord, this application is, my lord, innocuous. It's, my lord, for, my lord, extension of, my lord, time to file the written statement. But, my lord, I was praying, my lord, today is, my lord, let this application, my lord, stand over, my lord, 2 weeks, my lord, after the vacation.
It's your
Why,
application.
it's my application. Why, my lord, is, my lord, we are, my lord, in the process of, my lord, filing some other application. And
Well,
because of that, my lord, I don't want to, my lord, press this application as of now, my lord. Once, my lord, that is done, my lord, I will, my lord, press this application. As of now, my lord, I don't want, my lord, any order, my lord.
Okay.
in
No,
this.
Learned
what I
advocate.
the time to file written statement expired on 14th March. So I am giving my
I'm
consent.
not passing any orders today.
I'm giving my consent, my lord, that the
His
time
consent
be
is-
extended.
No. I'm
by-
not pressing this application to his the question of his consent
Let
does
him
not
say
come.
that, he's not.
For the
As of
defendant
today, my lord.
petitioner and learned advocate for the opposite party plaintiff are present. On the prayer of learned advocate for the petitioner defendant, the matter stands adjourned till 10/6/2025. The following day after reopening,
I know, my lord. Can it be, my lord, the week thereafter, my lord?
17/6/2025.
I'm deeply obliged, my lord.
Item number 5.
Lordship, I appear on behalf of the plaintiffs. Pursuant to your Lordship's last order dated 6th May 2025, we have served them a further notice. May I hand over? But it has been delivered as well, but none appeared as well today.
You have served the parties as well as their advocates.
No, your Lordship, the advocate on record on the last it also had indicated to your Lordship that the earlier as well advocate on record has refused, stating that they have returned the brief. That is why we are serving upon the parties only.
So you have served how? Personally?
Speed post.
Speed post.
Yes, sir.
Just wait till the second call.
My lord, I have heard the degree holder in this.
I came much number
6 minutes.
6. That is GA. Which GA is to be taken up?
Yes, first GA will be taken. 9 minutes.
It's GA 2918.
Yes, my lord. This is an application for setting aside the degree passed against the mandate. The degree part payment has been, degree has been satisfied, some payment has been due. My lord. This application has no effect.
You are the judgment debtor.
I am the degree holder.
Decree holder. Okay. So decree has been partly satisfied,
Yes, my lord.
but some payments is made.
Some payment is due. That will already execute my degree is there. This application not sent in the way.
Who is appearing for the judgment debtor?
There are so many advocates has been changed in this matter.
No, who is on the record?
On the record, last time, Jalan and Company appeared me.
Yes,
Jalan and Company.
the last occasion.
Yes. Last week. That is, fourth the advocate will change.
What was the last order passed by you? Again, order taken. No, no. Did I take up this matter earlier? Again, notice দিতে বলা হয়েছিল না? এই অর্ডারটা কোথায়? দেখুন। Is it appearing first time before this court?
No, no, this is the fifth or sixth time.
No, no. Question is. Hmm? So anyway, serve the advocate and come. I shall take it up on the next week. Yes, learned advocate for the decree holder is present. None appears for the judgment dated. However, in the interest of justice, the matter stands adjourned till 22nd,
Yes, ma'am.
22/5/2025. It is, however, made clear that in the event none appears, the matter will be taken up in their absence. Serve the judgment debtor and their advocate.
Okay.
Item number 7 is the group of three Vikas notes.
Yes, pass over.
Hello, may I please? It's my execution application, my lords. Seeking, my lords.
Filed by my client.
You are for?
I am for the judgment debtor. Seeking, my lord,
My lord, on
under
the
section 47, saying that the decree is inexecutable and the decree cannot be executed in
Is there any stay of execution of
no,
the
my
decree?
lords, no.
my application is being heard.
So when was your application
2020, my lords.
You got to hear my application.
Affidavits are exchanged in that.
Yes. It's been pending for the last 4 years, my lords.
Let's take it up.
Now, before your lordship takes up my 47, your lordship will kindly see there is a supplementary affidavit which my learned friend has filed in the year 2023.
Yeah.
After filing of my
execution.
yes, after filing of my 47 application. Kindly take the
Affidavits are
supplementary affidavit.
Supplementary affidavit, the rejoinder has been filed. They have also filed. No pleading.
My lord, lordship will keep the execution application and the supplementary affidavit.
Yes.
Kindly consider, my lord, they have practically now acceded to my points in my 47. The entire execution application has now been practically abandoned by the supplementary affidavit. Kindly take the supplementary affidavit and the tabular statement in the execution application.
That is the section 47 point. That is the section 47 point.
Now the court has to choose. I don't know whether this kind of an execution application is maintainable under the Civil Procedure Code. Kindly have a look at the tabular statement. Kindly see the amount what is claimed. Tabular statement account. Kindly see tabular statement. Net decretal amount is 13 crore 90 lakhs.
Yes.
This is their case.
Yes.
Now kindly take the affidavit in support of the tabular statement.
Yes.
Affidavit in support of tabular statement, your lordship will kindly come to paragraph 8.
Yes.
Paragraph 8, your lordship will see that they are saying about a terms of settlement. Under the terms of settlement, judgment debtor 3 to 7 was added. JM Financial Product was deleted from the array of parties to the suit.
No, paragraph 8, page 5.
Yes, my lord. Thereafter, paragraph 8. Decree holder and judgment debtor number 1 and 3 to 7 agreed to the following terms. So, what is the term agreed upon? Defendant number 1, that is my client, and the added defendant number 3 to 6 shall jointly and severally acquire by purchase at their cost 10 lakh equity shares of Gati Limited at 1 lakh shares per week starting from execution of the terms of settlement, that is 10 weeks from the date of execution of the terms of settlement. So this is my obligation to acquire. First is obligation is to acquire the shares.
Yes.
Number B. Defendant number 1 and added defendant number 3 to 6 shall provide all documents of purchase of 10 lakh equity shares of Gati Limited acquired by them to the plaintiff within 10 weeks from the date of acquisition of the terms of settlement. I will acquire, provide them documents of purchase. Number 3, C, kindly see. Such purchase shares would be transferred within a period of 6 months from the date of execution of the present terms of settlement to the depository participant of the plaintiff, TCI Finance, with depository participant Carvi Stock. Kindly note the next part. Simultaneously with payment of 5 crores to the defendant number 1.
By the plaintiff to the defendant number 1.
Yes. So that means I will acquire and purchase. But I will transfer when? I will transfer only when they will transfer 5 crores to me. So the obligation on my client to transfer is not separate and independent. It is preceded by a simultaneous obligation of their client to give me 5 crores. Otherwise, I have no obligation.
Yes.
Then, my lord, kindly see para D. Defendant number 1 and 3 to 6 shall pay interest at the rate of 15% per annum on 13 crore 90 on reducing balance method from the date of sale till the date of repurchase by them. To make terms more clear, it is agreed that upon acquiring 1 lakh shares by the defendant, the principal amount for calculating interest will get reduced by the cost of shares purchased. This reducing method will continue till the date the entire 10 lakh shares are acquired. So this obligation is on me to pay interest till the full 10 lakh shares are purchased by me.
Yes.
Similarly, para E. On the loan given by defendant number 1 to the plaintiff amounting to 5 crores, I had originally given the loan to him. Interest will be calculated as follows. So he will also be liable to pay interest on this loan amount of 5 crores. So from the date of 1st August till date of acquisition of 10 lakh shares at the rate of 15% per annum. From the date of acquisition of 10 lakh shares till the date of refund of loan at the rate of 8%. So this is the terms of settlement more or less which we had agreed. Now kindly come to their part. I am not showing any document on my part. Your lordship will not find any statement. Then kindly come paragraph 9 at page 8. I will go to the terms of settlement later, but I kindly see the way in which this execution application has been filed. Paragraph 9, what they say? As per the terms of settlement, the decree holder was to inter alia receive documents in relation to purchase of 10 lakh shares within a period of 10 weeks and the said shares. Stopping here for a moment. As I was placing the terms of settlement, your lordship found that they will get the shares only when 5 crores is to be paid by them.
Yes, fulfillment of the condition.
Paragraph 9, that statement is missing. Paragraph 9 misconstrues the terms of settlement as if my obligation to transfer is absolute and unconditional. Then kindly come to paragraph 10. Decree holder had till date not received any document of purchasing any share by the judgment debtor. The judgment debtors have failed and neglected to procure 10 lakh shares in Gati Limited. They agreed between the parties and transferred the same to the decree holder within the period of 6 months from the execution of such decree. Judgment debtor number 1, 2, 3 are jointly and severally liable for the same. Since the judgment debtors failed to take steps for as per the compromise decree, the judgment debtors are liable to acquire and transfer 10 lakh equity shares to the plaintiff as well as pay interest at the rate of 18% from such and such till realization. So what is the decree according to them? They are entitled to 10 lakh equity shares. Their case, I have not acquired. They will get 10 lakh equity shares and they will get interest. That is why I'm showing your the tabular statement. Now kindly see the tabular statement. The tabular statement simpliciter decretal amount says 13 crore 90. Kindly see column number 7.
Yes.
Decretal amount 13 crore 90.
Interested in it.
Have you got you found?
Yes.
No, that is my first question, my lord. Where does the decree say that they are entitled to a decretal amount of 13 crore 90? Now, my lord, when I filed the 47 application, I disclosed the documents that this so-called terms of settlement was further substituted by a fresh agreement between the parties. And when I disclosed those documents, I disclosed the documents that to show that I had purchased shares, I had given you document of shares, I had asked you to make refund and take shares. And from time to time, what happened? Since they did not make payment, I had no obligation to transfer. Then with notice to them, I had again sold the shares in the market because share prices were falling. So I had again given them notice to shares and I have claimed the differential amount. Now your lordship will kindly come to those documents in my section 43. Now just before that, when I made out this case, disclosing all the documents, now this supplementary affidavit kindly comes to the supplementary affidavit at page 3.
Yes.
Paragraph 2. In the present execution application, decree holder had calculated its claim in money terms of the consent decree at 13 crore 90. There is no decree for 13 crore 90. Then, para 3. On such and such, decree holder had a conference with their learned senior advocate. This is after filing of my 47. After all affidavits in my 47 was complete, then this paragraph comes. Had a conference with the learned senior advocate when it was advised that the said calculation is wrong and further advised that a supplementary affidavit with correct calculation be filed. In the above facts and circumstances, present supplementary affidavit is filed to incorporate the sum due to the decree holder in terms of the decree as on 28 February 2023. So, my lord, my first submission is therefore this execution application cannot be maintained. In a supplementary affidavit, can we change the case in the petition by a supplementary affidavit? Supplementary affidavit which we can only supplement facts stated in the petition. We cannot say that my entire petition is wrong, so you kindly consider this supplementary affidavit. So now your lordship will have to ignore the tabular statement. Your lordship will have to ignore the affidavit in support of the tabular statement. Now kindly come to paragraph 4, what they say of the supplementary. In terms of clause 5 of the consent decree dated such and such, the judgment debtor was required to acquire 1 lakh share of Gati Limited every week for 10 weeks from the date of terms of settlement and hand over the same to the decree holder. It was further decreed that in the event the judgment debtor failed to acquire 10 lakh equity shares or any part thereof, the judgment debtors failed to make over documents of purchase, the judgment debtors failed to transfer 10 lakh shares in time, the judgment debtors jointly and severally would be liable to pay interest at the rate of 18% on such and such for the period of delay, besides restoration of the shares of 10 lakhs. Decree hold now, first time they are coming by way of affidavit and they are accepting their obligation to make payment or refund of the 5 crores and interest. In the original execution application, that was a gross suppression. Paragraph 6, my lord, kindly see. Decree holder had an obligation under the decree to refund the same sum of rupees 5 crores along with interest calculated as follows. Paragraph 7 is the most interesting paragraph. In terms of the decree, 2 scenarios are possible. Scenario 1, scenario 2. But may I ask this question to myself? Well, is it a case of tossing between scenario 1 and scenario 2? Or a case of adjudication? If it is a case of adjudication, then it is not the job of the executing court to adjudicate. Executing court can only implement the decree. Nothing, executing court cannot make any form of adjudication as regards entitlement.
Executing court is bound by the decree.
Yes,
That is
bound by the decree. Now the question is, what does this mean, if I may ask to myself? In terms of the decree, 2 scenarios are possible. A decree does not contemplate 2 scenarios, cannot. Decree by its definition means it is a final adjudication of rights. It is not contemplation of any contingency. It says this has to happen and this is the amount. Here they are saying you calculate interest at the rate of 15% till the period of 10 weeks and thereafter 18%. But this is completely going beyond the decree. Now, therefore,
these are the case in the supplementary affidavit.
The supplementary affidavit goes beyond the execution petition, goes beyond the decree.
Tabular statement goes beyond the
tabular statement. How can you, may I ask this question to myself, how can the court consider a supplementary affidavit for the purpose of final adjudication, abandoning the case in the execution, in the tabular statement? My 47 will come, but let me first know what is his execution case. My 47 proceeded on the basis of the tabular statement. Tabular statement is now changed by way of a supplementary affidavit. Now, your lordship will kindly come to my 47 case. What is my why I say that the decree cannot be executed? It is inexecutable.
Your 47 is GA?
GA1.
GA1 টা কোথায়? GA1 টা।
Kindly come to, my lord, page 62. Before I come to the terms of settlement, your lordship will see, originally, I had filed kindly see, this is the suit which had been filed by my learned French client. at page 54, your lordship will get the prayers.
Yes.
Prayer A was, my lord, this was what had happened is I had given them a loan of 5 crores upon pledge of 10 lakh shares. They had pledged 10 lakh shares in for the loan which I had granted to them. Upon notice to them, since there was no repayment, I had invoked the pledge, sold the 10 lakh equity shares. They challenged that sale by way of this suit. Kindly see the prayer, page 54. Declaration that the invocation of pledge and sale of 10 lakh equity shares held by plaintiff in Gati Limited and pledged in favor of the defendant number 2 is illegal, null and void. Mandatory injunction upon defendant number 1 and 2 acquire and transfer to the plaintiff 10 lakh number of equity shares of Gati Limited. Decree for declaration that the letter undertaking declaration dated such and such be void, delivered up, and then decree. And then this suit which they filed was settled by way of a terms of settlement.
So this particular suit.
This particular suit which they filed.
Yes.
Kindly come to page 62, which is that terms of settlement.
Yes.
First clause is blood addition of certain companies as parties. This is not very material. They are all added as party defendants 3, 4, 5 and 6 to the suit and necessary amendment be carried out. Then important clauses start from clause 3.
Yes.
10 lakh equity shares of Gati Limited have been sold by defendant number 1 for a sum of rupees 13 crore 90 lakhs 18,015,542. This was their challenge. It is agreed that defendant number 1 and added defendant numbers 3 to 6 shall jointly and severally acquire by purchase at their cost 10 lakh equity shares of Gati Limited at the rate of 1 lakh shares per week starting from the execution of the terms of settlement. The defendant number 1 and the added defendant numbers 3 to 5 undertake that they will complete their obligation of acquiring 10 lakh shares within 10 weeks from the execution of the terms of settlement. So I will acquire within 10 weeks 10 lakh equity shares. Then kindly see 4. Defendant number 1 and added defendant number 3 to 6 will provide all documents of purchase of 10 lakh equity shares of Gati Limited acquired by them to the plaintiff within 10 weeks from the date of execution of the present terms of settlement. Such shares would be transferred within a period of 6 months from the execution of the present terms of settlement to the depository participant of TCI Finance, that is the plaintiff with client ID such and such with depository participant card V. Next part, kindly read, my lord. Simultaneously with payment of 5 crores by the plaintiff to the defendant number 1. First point is, my lord, they have committed a breach of this obligation. If they have not shown in their execution application that they had made the refund of 5 crores, then I had no obligation to transfer this 5 crores of the 13 lakh 90 shares.
Right.
If they do not perform their obligation, then where is the question of charging interest on 1390? Kindly come to the next paragraph 5. This is what they are doing. Defendant number 1 and 3 to 6 shall pay interest at the rate of 15% on such and such on reducing balance method from the date of sale till the date of repurchase by them. To make the terms more clear, it is agreed that upon acquiring 1 lakh shares by the defendant, the principal amount for calculating interest will get reduced by the cost of shares purchased. This reducing method will continue till the date the entire 10 lakh shares are acquired. So therefore, if you have not tendered any part of your liability of 5 crores, I have no corresponding obligation. Where is my obligation, if I may ask myself, to pay the interest? You have not shown anywhere, not a single pleading, even in this supplementary affidavit, that I was ready with 5 crores I offered 5 crores, but he did not transfer. Not a single pleading is there, and your lordship is asked to execute a decree for a net decretal amount of 13 crore 90 lakhs. This is the extent of suppression in an execution matter. But it does not end here. Now, my lord, kindly let me go to the document to show the further extent of suppression. Kindly come to thereafter page 74.
Yes.
It is dated May 25, 2017 at the top left, your lordship will get. May 25, 2017. Right,
Page
I'm sorry.
74.
Huh?
Page 74.
Yes, page 74.
Yes, May 25,
Yes.
2017.
It is being written by our client.
Yes.
Kindly make a note, my lord, this is being written by the judgment debtor. We would like to bring to your kind notice that terms of settlement dated 8 March 17 is relating to the loan agreement dated 19 February 2016. Other agreements are independent and to be followed separately. As far as the terms of settlement relate to loan agreement dated 19 February 2016 is concerned, we were to acquire 10 lakh shares within 10 weeks from the date of settlement. Kindly note, which we have acquired and complied with the terms of settlement. Has the lordship got it? So, my lord, even if we take the clause, interest stops to run once we have completed the purchase.
Yes.
Interest stops to run.
Right.
But kindly see what is the date? May 25, 2017.
Yes.
So before this date, the interest has come to stop running under the terms of settlement. Then kindly see further. So lordship is not told about this. Lordship is shown a net decretal amount of 13 crore 90 in the tabular statement. In the supplementary affidavit in scenario 1, your lordship is told that 15% has to be calculated from 31st August 2016 till 10 weeks and thereafter at the rate of 18%. So interest is calculated continuously.
Without giving effect to this letter.
Without giving effect to this letter. That purchase was already complete. But
any reply to this?
I am coming, my lord. This is further not over. I will show your lordship. Then, my lord, next paragraph. Further, we were to transfer these shares within a period of 6 months from the date of settlement, which we want to start against refund of proportionate amount of our loan. So we are saying we are now going to transfer it to you against refund of loan by you. We would like to highlight that from the date of acquisition of 10 lakh shares till date of transfer, we are only entitled to receive 8% per annum, which in fact was the spirit that we should transfer to you as early as possible. We therefore request you to kindly take part shares from us against simultaneous refund of proportionate loan amount and interest. Next line, my lord, please note that any delay from your side may result in selling of shares by the brokers, which will be solely at your own risk and cost, and we should not be held responsible for any consequence. So, my lord, what is the effect of this letter? We tell them that shares are acquired, you pay proportionately, I transfer proportionately. If you don't pay and I can't transfer, then I will have to sell to the outsiders because I can't wait. Share prices are volatile. If share prices go down and you don't take the transfer, then I stand to lose. So automatically I have given them notice. This is as early as on 25th of May 2017.
Yes.
Next page, your lordship will see page 75. Again, my lord, similar notice 31st of May 2017. At the top right hand column, your lordship will get the date. Reference to the subject agreement, please note that in spite of repeated reminders, you have not responded to our emails where we have mentioned that as per terms of compromise, we have acquired 10 lakh shares in the given time schedule and now want to return part shares out of the same against proportionate refund of loan, including interest. Any delay on your part may result in any consequences, including sale of shares by the broker. Then kindly see page 76, August 14.
Yes.
First, kindly see at the top, I am telling them your reply is still awaited. At the top, your lordship will find first message, dear sir, your reply is still awaited.
Yes.
And I am forwarding the earlier mail of August and saying that your reply is still awaited. Now kindly see the further mail of August. This is with reference to the terms of settlement dated 18th March 2017. Relating to the loan agreement, as per terms of settlement, we were to acquire 10 lakh shares of Gati within 10 weeks of the settlement. We were to return the same to you within a period of 8 months. We have informed you through various emails that we have acquired 10 lakh shares. Also informed you that we would like to return part shares to you against simultaneous refund of our proportionate loan with interest. In spite of our repeated reminders, kindly note this line, my lord. You have not been able to take back your shares. In between, the share prices have also fallen very sharply. In the given scenario, you are requested to make good the margin shortfall today itself, as otherwise the shares would be sold by the brokers and the same will be at your risk and convenience. So, my lord, kindly consider this. This agreement is this agreement which we entered into and a decree was passed.
That is terms of settlement.
Yes, it was a time-bound compliance obligation.
Yes.
Because I can't hold on to the shares indefinitely. If you are not in a position to take back the shares upon returning my 5 crores proportionately, I cannot hold on to the shares. So that is why I have given you repeated notices. You have not said anywhere that I am ready to take back the shares. Give me the money. I am here ready with the money also. So ultimately, the shares, I give them notice that the shares would be sold by the brokers. So what is the effect of this? That terms of settlement has failed. I am saying it is because of your breach. You can have several reasons, but is it the domain of the executing court? That is the question, which will fall for your lordship.
Whether these were not in the execution case, these incidents, this
suppressed. It is in the execution case brought by me by way of section 47. That there is no decree which survives for execution. Now, why I say that? Because this, after I have sold it, there has been a further agreement of the parties. Kindly see next page, 177. This is 28th of June 2018. This has reference to the caption subject. As per the terms of settlement, we had acquired 10 lakh shares and offered the same to you for taking back by refunding our loan and interest. However, in spite of repeated reminders, you have not taken back the shares, nor you have refunded our loan, including interest. We have, however, held the shares purely on the ground of relationship. Pursuant to our last communication, share prices of Gati have fallen quite substantially, resulting into further margin shortfall. Interest on the loan is also unpaid since August 2016. In the given scenario, we request you to make good the following payments immediately, as otherwise the shares of Gati Limited would be sold in the market, sold at your own risk and cost, without me being responsible in any manner whatsoever. This is my calculation which I have given to them. Net interest receivable from you after adjusting interest payable by us 33,50,000. Margin shortfall 1 crore 31. Total amount.
So this was the amount due and payable by them.
Now it has become due and payable by them.
Now
means in 2018 June.
Yes.
Because this terms of settlement was not complied with. And this amount became payable by them 1 crore 65 lakh. You are requested to make the above payment in our bank account by RTGS forthwith. So, my lord, where is now that decree embodied in the terms of settlement to be executed? There has been complete breach. Terms of settlement is also an agreement.
Yes.
It has broken down. Monies have fallen due to us.
So this is the last letter
No, it
granting him an opportunity
to pay.
Yes.
But this is my letter saying that terms of settlement therefore no longer remain. You have now become indebted to me for this amount. Now kindly see, first letter on their part is October 3, 2019, page 79 top.
Yes.
In 2019, they are coming and saying, with reference to settlement of the LAS transaction between Godavari, TCI Finance, such and such, please find enclosed herewith calculation of interest and principal payable by TCI Finance and Amrit Jal Ventures. Our calculation is based on court order, presuming that kindly note, that shares have not been acquired by you, as you have not provided us the demat statement confirming acquisition of shares. The above calculation shall be revised once you submit us the contract note for acquisition of shares along with the statement of demat account confirming the acquisition of shares and that you continue to hold the same. So in 2019, they are coming and saying that you have not given a statement confirming the purchase of the shares by you. But kindly see my reply, 8th of May 2017. Contract notes have already been given to them. The reply means, my lord, I have annexed that in the affidavit in reply.
In the affidavit in reply, you have stated that.
Yes, I have annexed that mail. But how many suppressions, my lord, your lordship will lose count of the extent of the suppression now.
Let me deal with it.
But,
I'll just indicate.
Yes, let him complete.
but I will take some time, my lord. Let me continue on the next day, my lord.
Okay. Mr. Sen Lanet, counsel for the petitioner judgment dated, is present. Yes, what is your name?
Ankun.
Yes, Ankun. Mr. Ankun Rai, appearing for the decree holder, is also present.
This is the opposition to the supplementary affidavit.
Mr. Sen commences his argument on the
Section 40.
of the application
G1
2021, but could not conclude the same. Let this matter appear when this before vacation or after? Let this matter appear on 10/6/2025 under the same position in the same position.
Obliged.
Let the affidavit in opposition and reply filed to GA 1 of 2021 be kept with the record.
Obliged.
Next matter, I'll be praying for only one line direction because the other side is not appearing on the direct.
Item yes, next. For the next.
Listen.
Item number 9.
It's a preliminary matter for. I am for the plaintiff decree holder.
Yes.
It's a suit. It's a partition suit. My lord, execution. My lord, application is my lord pending. Whatever, my lord, it's a suit. My lord, the decree, preliminary decree was of 2010.
Yes.
And my lord, the final decree was of 2018.
Yes.
Thereafter, Corona and the decree was to be executed. Thereafter, this application was filed. Everything is complete.
Submitted.
Meets and bounds, everything is complete. Only the remuneration part that is indicated in the last order. Today, the commissioner of partition, he is the person who is to be determined the remuneration. But according to us, we have paid excess. According to him, he was to charge by month basis.
Commissioner is present today.
No, he is not present. That is why only one line direction. Taking up the matter in the next week is a 78 years old old solicitor of this honorable court. He is an
Learned advocate
so
for
that I can serve, so that he can present.
Decree holder is present. It is submitted by the learned advocate. that the final degree has already been passed and the partition commissioner is required to be discharged upon payment of his balance remuneration. So thus this matter stands adjourned
Next
till-
week, any day.
or after vacation.
Well, not 78 hours person. Well, he is well, such a
Matter
very bad case.
stands adjourned till 22/5/2025 for obtaining necessary instructions.
And I'll serve a notice upon him again.
Learned advocates for the plaintiff is requested to sub notice upon
The learned
the other
commissioner,
side advocate and the learned partition commissioner.
commissioner of partition. Other side is not appearing in spite of service. MD floor, only this much one. Yes.
For the judgment decree holder, parties have settled their disputes.
There is some of
Terms of settlement is to be filed.
We have filed it, and in terms of that, the execution proceeding was stayed. There were some compliances. The defendant, the judgment debtor was supposed to make payments, my lord. By 27th March 2025, Lordship takes that order, my lord, of 27th March 2025, Lord. It is
1
recorded.
lakh.
Yes. Second page recorded, it is submitted rupees 1.5 lakhs towards settlement. Amount is still remain unpaid. This is being, my lord.
Thereafter, how much have you paid?
But we have paid entire.
This is 1.50 was due. That is what they are supposed to pay today.
Today we are paying it.
So
1.5.
all disputes would come to an end with this. And my lord,
Can be
only
satisfied only, my lord. There is one condition, my lord. The papers, my original deed and documents are lying with my learned friend's clients. So, my lord, what I propose today, let's sit in the chamber today. I'm paying the
Yes,
money.
the learned advocates for the degree holder and learned advocate for the
Can you
judgment
next
debtor
week?
are present. It is submitted by the learned advocates that upon payment of rupees 1.5 lakhs, the entire dispute will be settled. Stop. Learned advocate for the judgment debtor submits that his client is ready and willing to pay the amount in course of the day, but the necessary relevant documents should also be returned by the degree holder.
but there is no only request is that let them make the payment today.
Yes, we'll make it a payment
In
today.
these documents, the original deeds which are with me, we have already undertaken that. So we'll do that.
Okay,
We'll
let
return
the-
that after vacation.
No,
That's
my
the
lord,
only because my
that
client is not
is-
in town. I don't have these papers with
That
me.
is, my lord, that was
That's
the
the only thing.
understanding. Lordship will appreciate, my lord. Whatever it
Okay, let the payments be made by 20th of May 2025. I'm making it clear.
That they are carrying it today in court, so they can make it today.
20th of, I'm just giving them up to 20th of May 2025. Let this matter appear on 10/6/2025.
Malati if your lordship Malati will kindly appreciate Malati, these documents pertains to my Malati.
So they are bound to return it.
I will. I've given undertaking in court.
The moment you have paid that amount,
Yes,
they are
yes,
bound
but
to return
today
it.
we have brought it, and the understanding was today they will Malati give us.
That
the
is not
documents.
there. There is no simultaneous. But it is that they will make payment. I will give.
All
Yes,
these
my lord.
things
Only
did not
only
go
thing
down
is
in the
that
order.
my client is not in town. The payment be made. I'll
Okay, I'm
return the
giving it
document.
on 10th of
Yes,
June.
and then let them make the payment today. My lord, they are carrying the money in court today.
I have given opportunity to pay it by 20th.
28th, let's Malati in the it is also understood
Okay,
that my
20th May the
documents will also be returned.
the degree holder shall take necessary steps to return the documents within a short period.
Lordship is keeping on 10th. Kindly record. In the meantime, documents to be handed over. That would be the solve.
Peremptorily by 10th June 2025.
Yes. On return of it, we will come back with the
No, I
compliance.
made it clear, but peremptorily by 10th June.
Yes, absolutely.
Then in that case, my lord, may I just suggest, my lord, it's a your lordship, my lord. We are paying them, my lord, there is 1.5 lakhs remaining. We are paying, my lord, 50% of that 75. Today we are paying, and let there be a convenient date fixed by them. On that date, the exchange of documents will take place, because lordship, we know what happens after the payment of money, my lord. It will be troublesome. Lordship will appreciate.
What trouble, my
No,
lord?
no,
I
my
am
lord,
the decree holder.
I know that it's not between
It's
me
not
and
a
my
bargain,
learned
my lord.
friend.
I have won the suit for.
Absolutely. This is only, my lord, the last phase. We are willing
I
to
don't
pay.
think these complications would arise. We have.
Okay, why didn't
settled.
you arrange for
Yes, because
return of the
My
documents?
client is not in town. He will come back
So let him
in
come.
month of June. That's the only
Okay, I'm
thing.
just giving him another, instead of 20th May, let it be
We were told, my lord, even yesterday that the documents will be handed over.
Okay, by 30th of May?
Yes, my lord, we are ready with the cash.
Okay, 30th of May. Instead of 20th of May, I made it 30th of May.
Grateful, my lord.
So like they will make payment within 30th May. I'll give documents by 10th of June, my lord.
No, by if your client comes,
Yes, yes. If
return
my
it on
client
that
comes
day.
immediately, that next day I'll return.
He's not here. If he comes by 30th, you return it on that
He
day.
comes by
after
tomorrow, I'll give
31st.
tomorrow. Yes. Well, grateful. 10th June. আমার কাছে পড়ি তো।
My application.
পেমেন্টটা করবে ব্যাটার অ্যাপিয়ার করবে 10/6/2025.
It's my application, my lord,
Yes.
that for transfer of a decree.
Your affidavits are ready. Yes.
Lord, if your lordship kindly takes the application, my lord.
Yes.
Well, in the master summons, my lord, I have prayed for execution case number such and such.
Yes.
Be dismissed. Stay of all further proceedings in such and such and ad interim order. But my lord, I must say, my lord, this is a case where, my lord, this decree is required to be transferred from this honorable court to the court where the yes, we'll have this matter, my lord. My lord, here, my lord, the execution application proceeds on the basis that the judgment debtor does not have any asset within the jurisdiction of this honorable court. No. I am the judgment. Them. Yes. And they have said kindly. No, they admit that it is outside. It's in Bhubaneswar.
Page 18. Their affidavit in support of the tabular statement. 16, paragraph 16.
What is?
Transfer to the commercial.
So?
কি বলছেন?
Suit commercial suit চলে গেছে। The decree in part 2.
Decree in part. Passed in before the commercial court was.
Before the
commercial court came into.
The execution কি অসুবিধা আছে? But suit is being but this is a decree which they are executing, the partial decree.
No.
No. Decree was passed prior to the coming into force. Will it kindly see the
16.
tabular statement?
16. Passed in 2016.
Yes. Kindly, Millard, see the suit along with the application was listed before so and so on 5th February when Honorable Justice was pleased to observe the SY service none appeared to the defendant and directed the. No. And Millard, with respect, Millard, I also am not very sure. The balance of the suit may proceed with the what has that got to do with execution?
No, my lord, what I indicate,
This
part of the claim was, my lord, a decree was passed on judgment upon admission. My lord, we had put it by the non-commercial court. We had put it into execution. My lord, thereafter what happened? We noticed that the claim was on account of goods sold and delivered. Thereafter, my lord, that court was of the opinion that it was, my lord, of a commercial dispute had to be tried by the commercial division. This order was passed, my lord, I do not know, 4th of December 20. Yes. Now today, the execution, whether it will proceed here or it will proceed before the commercial division of this court only, My lord, I'm just trying to
Cannot be.
ensure that my yes, my lord. Yes, my lord. Because my learned senior friend is absolutely right. When the decree was passed, it was not passed by the commercial division. Yes, but at the same time, my lord, the suit which remained, my lord, the claim part of the claim which remained, it has now been transferred. Whichever may, my lord, we are. But I do not want any objection in future that this should have been done for commercial division or non-commercial. I just want to clarify that.
If
Whatever
my
my lord
learned
holds,
friend says, if my learned friend says that this court does not have jurisdiction to execute the decree, in spite of the fact that the decree was passed prior to coming into force of the Commercial Courts Act, then in that event, my lord, the execution proceedings itself will become bad. Absolutely.
Fine.
But this is a decree which is yes. So I don't see any impediment in the.
maybe look up this.
He
my
has
lord,
not
maybe
pointed
look
out
this up
this
and my
thing
lord
when he
come
was
to it next week.
examining on
No, it
20th
was
March.
filed before.
4th December it was transferred.
Yes, my lord,
20th
it
March.
was
I
filed.
will kindly see the conduct of my learned friend's
16th
clients.
November.
When Millard he proceeds with his execution application, he was well aware of the fact that this suit has been transferred in 2024. He obtains orders in execution against me, which are annexed to my application. Then he doesn't come and oppose that this court does not have jurisdiction.
No, I'm not opposing. Let my
Then
learned friend
why
not
are you
put
showing?
words in my mouth.
Then
I'm only here,
say
and let us not talk about the conduct. They are earning 60 lakhs.
that's
annum.
different.
No, we are
That's
talking about conduct. Then you should look at it from
now
the
you are
angle.
coming and coming before the
My
court
lord-
and saying that this court does not have jurisdiction. Yes.
Yes, ma'am.
But my learned friend is not taking that point because if he,
My lord, this is a
let
pure
him take the
question of
point, let
law,
him
my lord.
understand what the point he is
My
taking.
lord, since this is a pure question of law, whether this should be done before the
With respect, Millard, if he comes with a written note, Millard, I would not be able to understand the point because we won't be exchanging notes. So let him argue. Let me get a grip of what point he is arguing.
My lord, kindly allows me to come back. I'll
Come
whatever.
back.
I need to look this point up whether this should be done for the commercial division or
Taking
for-
both orally and written notes.
Yes, ma'am. Mine. Yes, ma'am. Very good. Ma'am. Gives me some time, my lord. We'll come back.
Execution এখানেই হবে তো? But at any day convenient to your lordship.
Let us come back after vacation.
Right?
একটু দাঁড়ানো পড়াশোনা করছি। My lord, kindly record that party that filed their opposition and declined.
And kindly will it stay the execution for the time being. I have not prayed for any interim order.
Supplementary affidavit কোনটা ফাইল করবে?
This question of jurisdiction has cropped up, will not stay the execution for the time.
My lord, I'm not proceeding with execution. We are.
Let it be recorded.
My lord, this is the court, my lord.
This is
We are
the
not
court.
proceeding with the execution. My lord.
But will not
No formal order is necessary, my lord.
This court will not.
My lord, there is no necessity.
Let
for
him
passing.
let it record. Yes. Oblige.
Supplementary যেটা ফাইল করেছে সেটার বলুন
না দরকার। Oblige.
কমার্শিয়াল কোর্ট ফাইল
My lord, I appear for the decree holder, my lord. Yes, my lord, kindly takes lordship's last order. Decree is satisfied. I have received the balance payment also, which was directed to be paid by the last order. My lord, it's 17th April 2025. There is an order passed by your lordship. Money was lying with the my lord office of the registrar, and my lord lordship's direction was that balance money which the decree holder was 2,79,213. My lord, this is the my lord draft by which I have received the my lord payment. Lordship can record satisfaction of the decree. I only have one last prayer, my lord. Some costs, my lord, because I had to, my lord, sufficient fund is also, my lord, there. Any amount which lordship feels, my lord, is appropriate, may some costs be awarded, my lord, in favor of the decree holder. My lord, they were actually not appearing since, my lord, the inception of the execution. My lord, suit was filed in the year 2000. This was a claim on account of mean profit. Yes. No. There was no, my lord, they vacated, my lord, without a suit. Yeah. Demand? That's a check. That's a check, yes. Lordship will record satisfaction of the decree. Very grateful, my lord. My lord, the copy of the check may be retained with the record. My lord, I appear for the, my lord, decree holder. My lord, there is an order which is.
With the affidavit of service. This is the order.
My lord, kindly.
I am appearing.
I'm here to go.
Matter, my lord. I'll indicate what my lord offense.
My lord,
So I
this is.
just want to say, my lord, that the decree, my lord, we have instructions that we are in the process of, my lord, filing an appeal, my lord, from this order.
Yes.
So,
My lord, kindly takes my lord's last order of 1st of May 2025.
and also a maintainability point I'm taking.
My lord, pursuant to lordship's last order, my lord, there is an, my lord, attachment or an order of injunction, my lord, on the account maintained in the name of land acquisition collector. The decretal sum which is due and payable to, my lord, the decree holders is in approximate, my lord, 14 crores and odd. So,
Yes, we want to file an appeal.
my lord, two things I have to say, my lord. There was one more direction. A report was called for from the registrar. My lord, kindly takes there is a report from the registrar.
How much amount is lying in the hand?
Lordship wanted to know what is the amount that is lying deposited pursuant to a challan and what is the accrued interest thereon. Well, today I am entitled to at least disbursal of, my lord, the decretal sum from that amount. There is no stay of operation of the decree. I am entitled to this order.
Not by this court, my lord. I will file
My lord,
the
kindly.
affidavit. Yes.
My lord, in execution, my lord, possibly there is no scope of filing an affidavit. In an execution proceeding, there is no provision for filing an affidavit. The only affidavit that can be filed in an execution proceeding is an affidavit of asset. They have, my lord, but no opportunity to file this is not, my lord, a contested hearing once a decree is passed.
No, if I am questioning, my lord, the maintainability, my lord, I am entitled to, my lord, file an affidavit. Also,
My lord, if this is, my lord, if this is, my lord, a ploy taken by judgment debtors, there won't be any execution of any, my lord, decree. Everybody will come and say, I will file an affidavit in an execution proceeding. Kindly visualize the situation, my lord, permitting a judgment debtor who has not challenged the decree to file an affidavit to oppose an execution. My lord, this will really change the law, my lord, then. Only affidavit is affidavit of assets in an execution proceeding. Let them challenge the decree if they have a stay. I, my lord, mentioned the matter yesterday. Lordship had recorded unless there is a stay, Lordship would proceed with the execution.
Want today itself, I don't know, my lord. I am in the process of challenging the.
I want, my lord, disbursal of the amount which is lying in with the, my lord, registrar. To the extent it is there, I want disbursal. There is no stay. Lordship will kindly pass that order.
Lord, may I very humbly submit? I am, if Lordship kindly takes up page 41. After page 41.
Lord, yes,
Lordship
after
will kindly
it
take
finished.
up the order. My lord, I'm sure my learned friend will permit me to make submissions. It's after page 41, the order from which this execution petition has been filed. Lordship will kindly take after page 41. Lord, the order of the execution. No page 41.
There's no page 40.
Your Lordship will kindly take up the order. This is how it has been served on us. Lord, this is the page after page 41.
Certified copy
You will kindly take up the certified copy of the decree.
And it's with the tabular state.
That's at the start, I believe, Lord. The first page, it's is an order of 29 pages, the first page. Your Lordship will kindly kindly note respondent number 3. Lord, this execution petition has been filed by respondent numbers 1 and 2. The first page. Lord, you will find the names are recorded. The next is over that page. The next page. Your Lordship will find respondent number 3. But that's one of the sister of petitioner number 1 and 2. But we are on the same boat. But today, this order also applies on us. It applies on us. But today we are filing an intervention application to be added as petitioners in the execution proceeding. Because Lord, whatever order falls from your Lordship, Lord, we are on the same boat, Lord, and we are also making the same prayer.
Lord, I am the state. I have twofold submission. One, my lord, is that I am, my lord, taking steps, my lord, in preferring an appeal. Number 2, this is not maintainable, my lord. Why? Because this was an award, my lord.
Is not a stay.
Wait, my lord. This was, my lord, passed by the collector, my lord. A certain decision was, my lord, given by the collector. A reference was made to the district judge. That order, my lord, preferred an appeal from there before the High Court. Your Lordship knows, my lord, Section 36, 37 CPC, my lord. An appeal court's order, my lord, cannot be executed before the appeal court. So I want to, yes.
Well, I'm filing the affidavit of service Lordship wanted me to serve.
Only three.
Respondent number 3. Let copy be served.
We are in the course of filing it today.
Submits that judgment
My lord, one prayer kindly records my submission that I am, my lord, praying for disbursal of the amount which is lying deposited with the registrar general. My lord, that is my lord prayer.
Not maintainable.
There is no stay. I am entitled to this order.
I am also making the same prayer.
50% already. Legal amount between at this stage. However, the same prayer may be. Just one, I'm meeting my friend. Not one submission. Not this. Not kindly make it not without prejudice to our rights and condition. Not because the decree, was passed by the district judge Alipur. No, Lordship said that only because we want to prefer an appeal. The point is not that an appellate court's decree. They'll have to go to the first court not to execute.
That's no longer the law. If that is the point, let them argue this point here.
Yes. And the other thing notice, the Supreme Court is closed till 19th of July. So kindly give us little more time. Instead of 60 June, kindly at least give us 2 more weeks. Not after that, we shall try to. Yes, I'm saying kindly give us 2 more weeks. Because we'll also.
5th of September 2017 is the division bench order.
Kept it on
December.
5th of September, my lord, 2017.
16th of
December.
Lord, your Lordship.
Yes, and
2024. 2024 is the order. We are, my lord, after 6 months here, my lord.
Lordship was given till 17 June. Kindly give it till 30th June. We shall do that. Within that.
So without a stay, my lord, in effect, this is an order of stay on the, my lord, decree holder's right to receive the money.
They are fully secured.
Security is not what the executing court is supposed to look at with deepest, my lord, respect.
Grateful.
No,
but Lordship has said that vacation match, we shall try before the vacation match. We'll have to try before the vacation match.
and maintainability point, my lord, is kept open.
Let them file application. Let them take all points under the sun.
Very deeply.
My lord, kindly gives me a leave to inspect the report filed by the Registrar General because that amount would be indicated in that report.
To all the
Very-
parties, to all.
But if I appear on behalf of the plaintiff, I had already handed over the notice served upon the defendants on 7th May, pursuant to your lordship last order dated 6 May. Yes, sir. Fourth November 2024. Thereafter, we had filed an application as well. And this has been filed in the month of March 2025. But before that, we had already filed an application within the period of limitation. But due to some technical defect, that application has been withdrawn. The order is at page 24 of my application. 5th March 2025 on. With a liberty to file for. Yes. This is that application. The GA9 is that fresh application. GA8 was the earlier application, which was withdrawn and with a liberty to file for.
Yeah.
Because it's been filed with the leave of the
Madam, this is my application for leave to sue the receiver.
The layers of the defendant number 1.
He hasn't got any say in this with regard to the application. Yes, your lordship's last affidavits are all complete as pursuant to your lordship's last order of 22nd of April. May I be permitted to file the affidavit in reply?
The opposition. Your date has already.
It is been now fixed, yes, and it is now fixed in July. The hearing is going on 7th of July, I'm told, my lord, there the date is fixed. So,
Checking the legal heirs of the defendant, how could
my lord, the leave was, yes, and with regard to the, in fact, the, my lord, may I be permitted to make my submission? The cause of action is exclusively against the party receiver, who is plaintiff number 2. Because I am not a party in the suit, my lord, and in fact, leave was taken.
This is my right to know.
My lord, may I be permitted to make my submission? Let me make my submission. It's my application. My lord, so far as my application is concerned, because I am not a party in the suit, a prayer was made by my client for the receiver.
Party
Yes, he is the
receiver.
party
So
receiver.
Plaintiff number 2 is my client, who is a receiver, also a co-plaintiff.
Yes.
Other parties are not represented.
No, because we sought leave to file the proceeding on short cause title, and that leave was granted because we did not know who the parties were. Now, in the affidavit in opposition, my learned friend, who is appearing for the receiver, he has given the full cause title of the suit. Naturally, I am not on that. Now, afterwards, the other parties are now appearing before your lordship, but my simple prayer before your lordship is whether I have a cause of action against the receiver to pursue my proceedings, and only limited to that, I have come before your lordship for leave to sue the receiver. I am not at all concerned with the outcome of the suit, which is pending before this court. And admittedly, yes, I am an employee in the property concern. Admittedly, my lord, the nature of the suit is for administration, I think partition and administration.
The defendant,
Now, so far as my case is concerned, the admitted position is that plaintiff number 2, the party, was also appointed as a receiver. It's not like a third party who was appointed as a receiver. In this case, he was a party receiver who was appointed. And admittedly, the position is that she has terminated the employment of the petitioner before your lordship. Now, whether that proceeding is maintainable or not, that is a subject matter before that court, which that court will go into. Today, all that I'm seeking is whether your lordship will only have to see whether I have a bona fide cause of action against the plaintiff number 2, who is the receiver. And I had already placed my reliance on a decision of the Honorable Supreme Court, which is reported in 1978, Volume 1, Supreme Court Cases. And I think I had handed over a copy. This is the reported case of Justice Krishna Iyer. Your lordship will kindly take up paragraph 4 of that order. The fifth line from paragraph 4, may I just place before your lordship. When a court puts a receiver in possession of property, the property comes under court custody, the receiver being merely an officer or agent of the court. Any obstruction or interference with the court's possession sounds in contempt of that court. Any legal action in respect of that property is in a sense such an interference and invites the contempt penalty of likely invalidation of the suit or other proceedings. Other important words that I'm harping on. Now, may I just read on? But if either before starting the action or during its continuance, the party takes the leave of the court. In this case, my lord, I have come after initiation of the proceeding before the other forum. The court, the leave of the court, before starting the action or during its continuance, the party takes the leave of the court. The sin is absolved and the proceeding may continue to a conclusion on the merits. So the merits of that case would be before that particular forum where I have approached. Now, in the ordinary course, no court is so prestige conscious that it will stand in the way of a legitimate legal proceeding for redressal or relief against its receiver unless the action, it is very crucial, I have to satisfy your lordship, that unless the action is totally meritless, frivolous, or vexatious or otherwise vitiated by any sinister factor. Grant of leave is the rule, refusal is the exception. After all, the court is not in the usual run of cases affected by a litigation which settles the rights of parties and the receiver represents neither party being an officer of the court. Because when my respectful submission before lordship is when a party even is appointed as a receiver, then he becomes an officer of the court. And it is the duty of that particular person to follow the decorum as is expected and to discharge the functions of a receiver. Now, he has been given certain rights maybe he is filing the necessary accounts with the department. I'm not concerned because I'm not a party. But from the disclosure made in the affidavit in opposition also, it is clear that the termination has been effected by plaintiff number 2 in her capacity as a receiver. The termination letter itself shows that she has issued it as a receiver of the property. Now, it cannot be a case that receiver is seeking a higher right that she cannot be sued. So whether I have a right in law to sue the receiver is also something which has to be tested. And because of this judgment, I think all that I have to satisfy before your lordship today is whether I have a bona fide case against the receiver and whether my client has been approaching the other court, which is absolutely frivolous or vexatious. Now, what has been filed in the affidavit in opposition? Yes, removal order before the tribunal. Now, regarding the merits of that proceeding, I am not going to address before lordship. Even then, I have disclosed my petition, which I had filed before that forum. And my learned friend has also come up with the written objection to that application before the other forum. But all that is evident from my reply also. If your lordship kindly looks into my reply, paragraph 4. I have categorized my submission that the fact, the employment, if your lordship will kindly turn to page number 3 of my reply. I have served a copy of this on my learned friend. Paragraph 4, may I just place before your lordship? A, the fact that the employment, so these are the following facts which are admitted. The fact that the employment of the applicant petitioner is terminated is not in dispute. It is also reflected from the document already on record. Second, the fact that the termination of employment is at the instance of Chandana Banerjee, the sole receiver, in suit number such and such is also not in dispute, which is also reflected from the correspondence itself for the termination. Third, whether such termination is just or unjust is a matter of merit to be decided by the concerned forum in which the proceeding is ongoing, which cannot be made a subject matter of the instant proceeding that I have filed before your lordship today. Fourth, the instant proceeding is taken out only for the purpose of obtaining leave to sue in terms of the settled proposition of law, which can be either before institution of a proceeding against the receiver or during the pendency of such proceeding, subject to the condition that leave is sought from the honorable court which appointed the receiver. Now, I have come before your lordship only because the receiver was appointed by this honorable court. That is the only reason why I have come before your lordship. Merely an employee of the suit property, and I'm a third party so far as the proceeding is concerned. But the fact that I am aggrieved by the action taken by the receiver against me and discharging her right as a receiver is what I'm aggrieved of, and therefore I have come before lordship only with an innocuous prayer of seeking leave to sue the receiver. Then your lordship will also see that one of the contentions in the opposition filed by the deponent in the case number which is pending before the other forum, I have also quoted that what has been her submission in the written objection, which is in paragraph 3, paragraph 4E. Your lordship will find I have set out paragraph 5 of her written objection, that as Srimati Chandana Banerjee is appointed by Honorable Calcutta High Court, she enjoys the status of an officer of the said Honorable High Court, but while impleading her in the instant case, no permission has been sought from the Honorable Court. That's the, yes. In opposition, the point that has been urged is, if your lordship will kindly look up, in paragraph 4 of the opposition now, at internal page number 3. First thing that they say is, application is vexatious and devoid of any merit. Second, they say is the petitioner herein is not a party to the instant suit, which is at unbended position. I'm not a party. It is for my learned friend to satisfy your lordship that a third party who is aggrieved by an action of a receiver, court-appointed receiver, cannot make out an application for seeking leave of the honorable court to sue the receiver. Then the third point, this honorable court cannot grant leave. I'm reading on paragraph 4 of the affidavit in opposition, 4th line. If your lordship will kindly see, This honorable court cannot grant leave to a non-party to a suit to initiate legal proceedings in a different forum against the receiver appointed in this suit. Now, this is a legal proposition that my learned friend has to satisfy. Then the allegations against the receiver are vague, baseless, and without any merit. Now, pausing here for a moment, the fact that I have to show is whether my employment is terminated, which I have shown. That allegation, that such termination. No, on the contrary, Your Lordship, in the affidavit, in fact, if Your Lordship looks at, she has annexed the termination at page number 11. Kindly come to page number 11 once. Page number 11 is the termination notice. Now, Your Lordship will kindly see who has issued this. Chandana Banerjee, sole receiver in suit number such and such. So, she has acted in the capacity of a receiver. She's not acting as an individual or a party in the suit. She is acting in the capacity of a receiver, court-appointed officer. So, all that I had to show, and in fact, it has come from my learned friend's affidavit, that this was issued by my learned friend's client. So, all that today Your Lordship will consider is whether the termination has happened or not. Second, Your Lordship will kindly see, please collect your final dues, if any, from the accountant on any working day during working hours. You are hereby dismissed with immediate effect. Now, the termination is also on immediate basis. Now, she may have taken steps against my client, gone before the police, done whatever. But the fact that the employment is terminated is not in dispute. Then we filed, Your Lordship will also see. Yes. Page number 12 is what they have filed as a written objection to my application before the other forum. That's their disclosure. Where paragraph 5 is crucial, that I had placed in my affidavit in reply also. Now, whether the other points which have been urged in the affidavit in opposition, if I may just go back quickly to paragraph 4 onwards, Your Lordship will find in page number 4, last 4 lines of paragraph 4, the petitioner cannot seek any relief from this honorable court. Why? Because they say that I am not a party to the proceeding. Next, no case has been made out in the said petition for this honorable court to grant leave as sought for. That is for Your Lordship to decide whether I have made out a case or not. The prayers as sought for are not such which are granted on mere asking. I am not even for once questioning the fact that it is only for mere asking that should be granted. I have shown on, in fact, on documents also, I have given sufficient records, disclosed merits on record. The documents will speak for itself, that whether she has been terminated and what steps I have taken since the termination, the show cause notice which was issued to my client, the response to the show cause notice. Now, whether the response to the show cause notice is satisfactory or not is for the other forum to go into. That is not for Your Lordship to expand the scope of the proceeding. That is my respectful submission before Your Lordship. Then Your Lordship will read on paragraph 5 of the affidavit in opposition, which is absolutely on merit. Sudip Mukhopadhyay, the petitioner, was inducted sometime in 1998 by the erstwhile joint receivers as a typist and continued his service till December 29, 2023, when his services was terminated for dereliction of duties. He acted against the interest. So, pausing here for a moment, service is terminated, is admitted. Whether for dereliction or not, that is a question to be gone into in merit. He acted against the interest of the estate of Devi Prasad Mukherjee. Again, pausing here for a moment, whether I acted against the interest and whether that is maintainable or not, these are all matters of merit. These are not something which is to be gone into at this stage. Because if today Your Lordship decides that, yes, that court does not have jurisdiction, then it is usurping the jurisdiction. That is my with deepest of respect, that's my respectful submission. Your Lordship will only consider whether this application has got sufficient merit or not, whether I have a bona fide cause of action or not, and whether it is permissible in law or not. On 3 counts, I have tried to satisfy your lordship by relying on the decision of the Honorable Supreme Court. And your lordship will also see, they have also urged that my client had intentionally uploaded confidential information details of Mukherjee House in social media, thus causing harm to the estate. Now, nothing was posted in social media. It was by mistake, something went on his WhatsApp status. That is not posting in social media. But even then also, if I take it at the highest, even then that is also on merit. That is also not something which your lordship will decide. So that is my respectful submission, that under the circumstances, whether your lordship will be kind enough to consider my prayer and will allow the application and let the other forum, keeping all questions of maintainability open there, let the other forum decide once and for all. The learned receiver cannot claim immunity. That is my respectful submission. As a party receiver, she has the responsibility, and if she has acted in breach of her duty as a receiver by wrongfully terminating my client's employment, then for that, whether I have a bona fide cause of action or not, that is the only thing which I have to satisfy before your lordship. Those are my respectful submissions.
My learned senior friend Sat Hamad, I am the defendant number 1 in the suit. The receiver was appointed in my presence. Now, my lord, today I am dead. My legal heirs want to come into the picture. Whatever is falling from my learned senior friend, I should get an opportunity to combat that, my lord.
Man. So far the
Well,
suit is
receiver you
concerned, today on the technicalities, my lord, my learned friend has taken a leave to file the petition on a short cost title. I'm not on that. But if you look into the entire cost title, what you will kindly see that I have placed in my opposition the cost title of the suit. There are 4 plaintiffs. There are 2 defendants. Now, this is the partition suit, partition and administrative suit. The receiver, I was appointed as receiver, a party receiver, on consent of all the parties. Justice Ashish Chakravarti's order, my lord, it records that on consent of all the parties, I am appointed as a party receiver. Today, my lord, the notice of motion, which is with the notice of motion of the master summons, whatever it is, the notice of motion, I believe, my lord, which is master summons, the master summons, which has been taken out, I find the notice of motion. Notice of motion. The notice of motion. No. Notice of motion. Then is that should have been a master summons. Notice of motion then cannot be a chamber measure. Whatever. I'm not on those. So technicalities. Now the notice of motion which is taken out only against my client. So the other co-plaintiffs and the other defendants are today not being served. Whether they have died or alive, I'm not on that scope. I'm on a much preliminary position. Now, a person who is not a party to the suit, he is applying to the court for a short cost title. That's a different issue because he may not have the original say rules requires a long cost title. But that does not excuse him from serving a copy on all the parties. The reason why I'm saying, Manor, I hold a dual capacity. Yes, I'm a receiver. I'm acting as a receiver. It has to be a master summon. And another thing, and it is a notice of motion. It must be accompanied by a petition. A master summon accompanied by a affidavit in support of month. Here, what happened is a notice of motion along with a petition. So, in any event, it can't be before the chamber. But petition. So, in any event can't be a chamber business. So, these are all once again technicalities. But I'm not, whatever is fell from my lord. But to serve the parties, because I am having a dual capacity. I am a co-plaintiff, also as a receiver. Today, I am being sued this application in the capacity of a receiver. But my actions are under challenge. My actions vis-a-vis the suit property is under challenge. My actions vis-a-vis the suit property of which the parties are interested are under challenge. Any order passed will affect the parties. Has to be.
Apart from the technicality, my lord will
Not rightly, wrongly, my lord. Well, embarrassing. Whatever order is not there.
My lord, yes, I admit. In fact, I also did not notice this, that this is by my way of not by Master Summons. I'll come back. Your lordship will grant me leave. No, I don't think it can be altered like that. I think I have to withdraw and then file it afresh with the on the self-same cause of action. It can't be amended, is what I understand, because it has to be then by way of an affidavit. The same thing, but in the way of an affidavit. But the entire exercise which has happened in the meanwhile, yes, because service, my simple submission is that it is not a fact. With my deepest respect, I'm submitting this. It's not a fact that I'm aggrieved by any of the action taken by the receiver in regard to the suit property. No, I'm only challenging the action of the receiver with regard to the termination. And that is the limited scope. And whoever is aggrieved and whoever has got a say is the receiver whose action is under challenge. And I'm only praying for an innocuous relief to sue the receiver. The others cannot come and say. But if your lordship will also, it's defective. As on date, it is defective, and it's a proper ground to also take, which has fallen from your lordship. But the only problem would be the entire exercise which has happened in the meanwhile of filing of affidavits. Then the entire then the entire thing will be unnecessarily extended.
No, in the new app, in the when we file, then she's withdrawing it, filing afresh. You can annex these pleadings in the new application so that we cannot resile from these pleadings. You can annex these pleadings in the new application as an annexure to
My
the
lord can
that can be.
I can only make one prayer. It's subject to your lordship again to consider it. If your lordship so grants me the liberty of withdrawing this application, and with liberty to with liberty to file afresh by way of disclosing the same pleadings as in by way of an annexure to that application. But unnecessarily that will create a commotion. Your lordship has heard my learned friend. I had not served on any of the parties. It is the learned receiver who has come and who has ensured that the others are present. Yes.
Yes, is that
Yes, your lordship will kindly consider and grant me the liberty and to file it on the self-same cause of action by disclosing my petition as in by way of an annexure to the application, because that way then I think it can be shortened. The pleadings, whatever has been
pleading you can annex.
I mean, pleading and
It was appointed by consent of all the parties.
that is not in dispute.
The consent also came from me.
Dana. Yes.
I'll submit. I'll submit that. I have not I'll not completed my
Yes.
submission. I have not completed my submission.
If it is filed afresh, then I should be made a party.
Yes, very well. We shall do that.
Mine.
My lord is also giving me the liberty of mentioning the matter for early hearing.
ফাইল করার আগে লিভ দেবে কি করে?
File করে obviously. Yes. Grateful to your lordship. Will it be your lordship's pleasure?
Disposed of. Disposed of. Dismissed.
Your lordship, will it be your lordship's pleasure to also record that since arguments have been made at length, the parties is directed to file their written notes of argument also?
Let the application come. Is
Because
observation of
whatever
my lord?
has fallen from your lordship,
Yes. Yes. I will remember this. I'll remember this.
very well. We shall come.
If I am still in the matter, I'll remember this. Yes.
Yes, he will be making his submission. Yes.
My lord. But let the application come. It is not yet born.
তাই করে আসবো, অসুবিধা নেই। Grateful to you. ওরা তো ফুল টাইটেল দিয়ে বলছে, চুজ করে টাইটেলে করবে।
Lord, mentioning a matter, my lord, I am out of turn, my lord. It was due to appear on the 13th, my lord. The order is there.
It was mentioned again on 13th.
But we had mentioned this on 13, but it didn't appear. Lord, if it can be listed tomorrow, it was supposed to be appearing today. It didn't appear today as well. We had mentioned before this, my lord. So kindly direct only for filing of the receiver's report.
Yes.
Well, let it appear tomorrow if your lordship so pleases, my lord.
The receiver is not available from next week on. Yes, এটা কালকে ইয়ে করে দিন লিস্টে।
I mean 16 years.
Grateful, my lord.
Yes, sir.
Slip to the other.
Time fixed.
লিস্টটা কোথায়? লিস্টটা
Item number 15.
That 15 minute was taken up yesterday when I had prayed for leave to file my Wakalatnama. But I appear Manad, on behalf of one of the trustees of the trust constituted under the will in question. But Manad, there are two errors Manad, in the order. One is Manad, the PLA number has gone down wrong. PLA 102 of 1993 ought to be PLA 102A of 1993. But this is how it is appearing in the list as well. In the list also PLA 102 is only mentioned.
So it should appear as
102A of 1993 as far as our knowledge goes. But
oh,
Manad,
is the cost title PLA 102A?
Yes, 102A of 1993. Cost title is the same as it appears in the order as well as in the list. Cost title is correct.
Yes.
But Manad, the PLA number would be 102A.
Okay, so let that
Yes, but
matter
that
appear in
correction
the
may
proper.
be, yes, that correction may
Give the slip, let the matter appear.
Well, it may be done today, so Lordship may correct that portion only.
Let it appear as PLA 102A of 1993 be listed tomorrow.
Okay. And my lord, the other correction, it's mistake on our part. That the first line, learned advocate for the executor is present. We are not for the executor. We are for one of the trustees of the trust constituted under the will. Lordship may kindly, because if
Let
they
it be corrected tomorrow under the
Very-
proper
my-
heading.
my- I understand.
So in the cost title, is it appearing correctly in the order?
Cost title is appearing correctly
But PLA
in the order as well as in the daily list. But the file, the record which is there, insofar as PLA 102 is concerned, that is of a different matter. Record before your lordship.
So that record has to be brought.
Yes, that 102A records have to come.
102A record.
Yes.
No. In this is 102.
This is 102.
Yes.
But this is erroneous. The number is erroneous. Although the cost title is correct.
Yes. So 102A record should come.
Yes.
But that record has not come.
That record we have checked, Mala, that record has not.
Let 102A of 1993 be listed tomorrow and the records be called for.
Well.
So let it be on Monday.
May appear on Monday.
On 19/5/2025, ঠিক আছে? Appear on 19/5/2025.
Yes. Grateful.
My lord, this is appearing pursuant to my it being mentioned yesterday. My lord, I had prayed that since their witness was being examined in chief, my lord, a time be fixed. Okay, my lord, because if your lordship is kind enough to take the order dated 29th April.
Give the order.
Yes, my lord. And there is a typographical error, Lord, which states, my lord, that in the second paragraph the witness was present, whereas the witness actually was not present.
On 8th May, the matter did not appear. The matter
No, it was not taken up, my lord.
When it is due to appear, this
My lord,
matter.
it's due to appear on 12th of June. My lord, I was humbly praying, my lord, that a time may be fixed at the convenience of the court, so that my
What
lord.
is the order fixing this matter?
My lordship was called the matter on 13th June and fixing the matter on 12th
May.
13 May, sorry. 13 May and fixing the matter on 12th June.
Fixing the matter
Since
on
the 12th June.
12th June.
Yes, since the plaintiff was not there, my lordship, and the matter fixed on 12th June.
Yes, record an order. Learned advocates for the parties are present. By consent of learned advocates, the matter be fixed. The matter which is already fixed on 12/6/2025, 12/6/2025, he appear at 3 p.m.
Grateful.
Grateful.
And my lord, the correction needs to go down. The
Which
witness was
correction?
not present. It's wrongly gone down that he was present.
The correction of the order dated 29th April 2025, which wrongly records that the witness for the defendant number 3 is present, be rectified, and made that the witness of the defendant number 3 is not present.
Was not. I'm grateful.
Grateful.
Lordship had been pleased to hear this application
Yes,
for
pick
them.
for orders today.
Yes, my lord. The preliminary decree.
Yes. So prayers are all allowed. Let there be an order in terms of prayer A, B, and C of the notice of motion dated September 2020. Plaintiff do get a preliminary decree declaring his ownership to an undivided 1/2 share in lot number 1 and 3 and an undivided 3/4 share in lot number 2 of premises number 78, Rafi Ahmed Kidai Road, formerly 78 and 78 by 1 Rafi Ahmed Kidai Road, Kolkata 7,13,000, more fully described in Schedule A, and the defendant number 1 to get a declaration of ownership of 1/2 share in lot number 1 and 3 and an undivided 1/4 share in lot number 2. The special officer, Mr. Khagendranath Jana, advocate so-and-so, is appointed as a partition commissioner to cause partition of the suit property by metes and bounds in terms of the preliminary decree and submit a report by 2/7/2025. So the remuneration of the partition commissioner is also fixed, and 2nd July 2025 for report of the commissioner.
After the partition commission. Yes.
Yes, report of the partition commissioner.
Grateful.
I'm extremely grateful.
Yes, next.
Well, look, this is that matter where I'm sure they'll pray for adjournment, so I'm
So
opposing.
conclude the matter.
Yes, I'll conclude.
No, they are appearing.
Yes, I'm for the judgment letter, Your Lordship.
Well, Lordship, may I-
Led by Pradeep Kumar Datta, Senior Advocate, Your Lordship. He's on legs. If Your Lordship would kindly give a passover and an adjournment. We have completed our
I
submission. Your
knew
Lordship.
they will start. Yes, they have completed, so let me make my submission. You make a submission if there
This
is.
direction on last occasion to file affidavit in reply. That they have
Give the
served.
copy.
Yes.
Yes,
we
yes,
have
we have given all that, madam. We have given all that. Lordship,
The
kindly.
last occasion, they have prayed for an adjournment, Your Lordship.
No one ever. We never prayed for adjournment. The last thing we'll ever claim.
So I can do one thing, Mr. Mitra, I can keep it tomorrow within first 5 matters.
First five. First five.
Yes, learned advocates for the parties are present. On the prayer of learned advocate for the judgment data, the matter stands adjourned for the day. Let this
Grateful, Lordship.
matter appear tomorrow, 16/5/2025, within first 5 matters.
Grateful.
And Lordship, kindly say that no further adjournment.
Definitely,
Yeah,
only
otherwise,
their presence is required. You have to reply.
yes, so I am prepared today also. So
Tomorrow, Your Lordship.
Give your notes also tomorrow.
Notes.
Notes of arguments. Written notes.
Lordship,
If you can.
by tomorrow may not be, but tomorrow I conclude my hearing
Yes,
by.
yes. Anyway, tomorrow within first 5 matters.
Grateful.
I beg to appear for one of the beneficiaries online, Your Lordship.
My Lord, I
The
don't
Maharani.
20 are my application.
Respondent number 1.
My Lord,
Application, your application, which one? GA?
GA number 9 of 2018.
No. Item number 19.
19.
Records are not a kagoj asheni naki? Huh? Okay, records have not come.
My lord, kindly fix this matter after vacation any day.
Yes. Learned advocates for the parties are present. Let this matter appear. Yes, I'm keeping it on 12/6.
Well, these two applications.
Yes, my lord.
12/6.
19 and 20, item number.
No, my lord, after 12th, my lord.
After 12.
Any day, my lord, after 20th June, my lord.
20th June.
Let this matter appear on 24/6/2025.
Complaint.
Well, not only
19 and 20, both.
19 and 20, my lord. These are my applications.
Okay.
My lord,
On 24th of June.
24th of June. My lord.
seek leave of the Honorable Court to file appropriate application. The leave এর application file করতে হবে এমনি কি করে the special officer in this matter
21.
ঠিক আছে
Yes.
in the previous matter only the special officer has given a report. The special officer in
Which
this
one? 19?
19 and 20
No, 19 and 20 হয়ে
হয়ে গেল,
গেছে,
এটা 21
21.
21.
Mala, the special officer has given a report. এটা আছে একটা copy. Well, it's a report where, my lord, there's a resolution which has been taken by the special officer and the members of
21,
the
this
committee of management.
GA15 is your application.
GA15 is my application for sale.
Yes.
If you remember, my lord, this is the matter where, my lord, we had made the advertisement for sale. My lord, no bidders came on the last occasion, my lord. So, my lord, we were deciding, my lord, your lordship was considering whether to make the plots into smaller portions and have them sold. It was a large property for 300 acre.
In this
So, my lord,
case, special officer submitted a report.
special officer has filed a report. In the report, the special officer has sought leave of this honorable court to file an appropriate application. This leave is required, my lord, then the application can be filed.
Record ta dekhi.
একটা কপিটা আমার পাঠিয়েছিলেন না মেইল করে Nowhere, Nadir. A meeting held on 15th May.
So 15th May, the matter is due to appear.
Yes, madam. Meeting held on, if your lordship sees 9th May on virtual platform, and if your lordship takes page, my lord, page 4, I think. My lord, where the resolutions is mentioned, my lord, under serial number 2, it is unanimously resolved by the special officer, the members of the committee management and beneficiaries in attendance to seek leave of the Honorable Court on 15th May to file appropriate application for termination of contractual agreement of lease, deed, and delivery of possession before the
So
High Court at Calcutta.
this application was served upon the special officer.
Yes, my lord. So special officer after that, my lord, has
After
inquired.
receipt of this application, he has sought for time to submit necessary application.
Yes, my lord. He wants leave for that application to be filed. Without his leave, without your lordship's leave, my lord,
Yes.
he cannot file any application. Appropriate leave is granted for the
Learned
special officer. to
advocate
take
for
steps.
the petitioner is present. GA15 of 2024 is taken up for consideration. Hard learned advocate. It appears that the learned special officer in this matter has sought for leave from this court to file appropriate application for determination of lease and delivery of possession. Thus, necessary leave is granted to file the application. The matter may be mentioned by the petitioner upon the necessary applications being filed. So you
Yes.
mention upon the necessary
Upon it being filed, yes, my lord.
necessary applications being filed and served upon you.
Yes, my lord. All the respective parties.
Yes.
After copy to 2025.
The application for the time being is adjourned.
My lord, a copy, it my lord, the copy may be kept on record. The report.
Report is not there, original report.
But this is the original report which was given to us.
Original report
May be
is
kept
there.
on record. Yes, my lord.
So if the original report is there and copy is already circulated,
Yes, my lord, through email.
then you can take
Through
back your
email,
copy.
yes.
If the original report is there and copy is circulated, you can take back your copy.
May the copy be kept on record once the original is there,
Copy
we
of the
take-
copy of the
copy of the report.
receiver special officer's report be kept with the record.
Oblige, my lord.
Oblige, madam.
This is my application. Now the suit is for is in respect of a partnership firm for dissolution of the firm and for partition of the assets of the firm. In connection with the suit, a preliminary decree was passed where partition commissioners were appointed and now there are joint special officers. An order was passed by this honorable court with regard to valuation of certain suit properties.
Yes.
That valuation has been carried out. The valuation report is there. We have prayed initially for direction of sale of one of the properties. In this application, I am praying for an order with regard to sale of certain other suit properties. But if your lordship kindly takes a look at my prayers first, kindly comes to page 20.
Yes.
I've prayed for an order with regard to direction on the joint receivers and commissioner of partition to take steps for sale of the properties. And to cause publication, provide inspection, and all necessary steps with regard to the sale. Kindly comes to paragraph 15, your lordship. These are the properties. Page 18. At page 18. Paragraph 15, is at page 18. These are the 4 properties.
Valuation has already been obtained.
Valuation has already been done.
With regard to all these properties.
In respect of all these properties also, your lordship would kindly have a look at page 180, which is in the second volume. This is the valuation report.
180 dekhi.
180. 180. 189 হবে না এটা দেখো তো 189 না 189 I'm sorry 189
এটা নোটিস অফ মোশনটা দিয়ে দিন একটু থাকবে আচ্ছা ঠিক আছে দেখছি
$189.
Yes.
Your lordship would find from this report, which really starts from page 191.
Yes.
Kindly turns over to 192. Different sites, different properties have been valued. Now, the valuation of the first property, your lordship would find the final valuation is at 194, 2 crore 18 lakhs. Now, the second one is at page 203, 1 crore 50 lakhs.
203.
203, your lordship.
Yes.
Then, my lord, the third one is at 212, which is 5 crore 51 lakhs. And if my lord kindly turns to page 220, this is the fourth property. Valuation is 32 lakhs.
Okay.
Well, these are the four properties tabulated in paragraph 15 of the application.
Yes. The properties, these are all vacant land.
Well, some are vacant land, some have structures,
Any
but everything
occupied
has been indicated in the report.
Any occupation in those said properties?
Nothing that we know of, my lord. It's not yet it's not been stated in the valuation report.
Okay, land and some structure is there. Yes.
Structure is there.
That is a C. Land and structure.
Yes. Now, my lord, this really would inure to the benefit of all the parties to the suit, because once the properties are sold, then, my lord, the money would be coming to the joint receivers, and the parties to the suit, in accordance with their shares declared in the preliminary decree, would get their shares. So this really, no defendant can join issues with this application unless a defendant is occupying a property solely to get his benefit out of that, or who is earning solely to the exclusion of the others. Otherwise, no defendant can object to this application.
Any opposition file to this application? No opposition file.
No opposition file. I am moving this for the first time, my lord.
Opposition is required.
Yes.
And
For the majority of the defendants, my lord, we also want to sell these property.
Your Lordship, I appear on behalf of the defendant number 9B. Your Lordship, I would like to use an affidavit to this. Your Lordship, I'll tell you why. Your Lordship, previous to this, there was a order passed by Honorable Justice Vivash Patnaik, the 10th February 2025 order, which has been enumerated in this application. Your Lordship, to that, we've preferred an appeal. Mr. Gorai is leading me in this matter. He had already indicated.
What is the order passed?
Your Lordship, the order was passed with respect to another property, which was the subject matter property in GA 25, that being sold. My Lordship, with respect to that, steps have been taken. My instruction that the valuation has been complete, and there is no stay of that order. Of course, Your Lordship,
Question is,
Your Lordship, however,
what is the order passed?
Your Lordship, I'll just.
Okay, here is the order.
Yes, Your Lordship. 10th February 2025, Your Lordship.
Yes.
Your Lordship, that was. Yeah, it is annexed to your
volume 2.
Your Lordship is kind enough to take page number 183 of Lordship. 183 in volume
Okay,
2,
that
Your
is-
Lordship.
No, page.
183 in volume.
Page 5 of the order.
Page 5, Your Lordship.
Yes.
Internal page 5. Yes, Your Lordship. That was my application.
Your application.
GA 25 was my application resisting.
GA 18. GA 18 2022, an order is also passed.
Yes, Your Lordship. Now, Your Lordship, from this order has been assailed in an appeal which has been filed, Your Lordship. It's pending. It's yet to come up for hearing. There is no stay.
No. This is with regard to the sale of these particular properties. Are these properties subject matter of dispute?
These 4 properties, no, Your Lordship.
Then,
Your Lordship, my humble submission over here.
Yes.
Your Lordship, these properties, of course, these are properties of the partnership firm.
Yes.
I am a partner of this firm.
Yes.
Of course, I have an interest over here.
Yes.
Your Lordship, in the property in GA 25.
No. What is your interest at this stage with regard to the properties?
Your Lordship, at this stage, my limited instruction on this count is that, Your Lordship, at this stage, if these properties are sold, Your Lordship, essentially it would not inure to the benefit of the firm. Your Lordship, I have a vested interest over here, vested to the extent that
the firm is dissolved.
Yes, long back.
So when
1976 suit.
Firm is dissolved.
So firm is
50
dissolved.
years the firm is dissolved.
So after dissolution, the properties are to be sold.
Have to be sold.
And it is to be dispersed.
Yes.
Only thing is this.
And
whether
kindly see
reasonable
why the
valuation
application
can-
was dismissed. Kindly sees it is in respect of which property. This is in respect of a property at Rajgarh in Rajasthan, where there was some third party who had filed a suit whose order has been vacated, which the joint special officer submitted on the last occasion.
I will look at the order has not been vacated by way of an order 2041 rule 27.
I do not know why he is joining issues with a third party suit, which is against the partnership assets.
Okay, let him file an
No,
affidavit.
my lord, kindly do not give them any leave. My lord, affidavit is not their right. Affidavit is not their right. Kindly, there cannot be any question of bringing any document on
this
record.
application filed?
No, nothing has been filed.
No, your application, when was your application filed?
This application has been filed recently, my lord.
Recently?
Yes. Now, there is no question of granting them any opportunity to file any opposition, my lord. Kindly takes a look at this application is filed on the 12th of March 2025. My lord, they had filed that appeal on the 27th of March. They have not yet moved, not served on us. So
See what is his interest?
Yes, kindly cease.
No. Let him state it in the record.
Kindly do not permit them to use any affidavit. This will take a lot of time.
No, it will not take a lot of time.
It will kindly will not permit filing of affidavits just for the asking. Kindly cease their stand once. That will be evident from the order and their previous application. Kindly takes a look at page 183. Kindly do not permit them this. This is what they want. They want to put a spanner in the wheel because they are enjoying certain suit properties. They are unilaterally
occupying these suit properties.
They are unilaterally, not this. They are unilaterally letting out suit property for ceremonial occasions.
No, are these properties vacant?
They only want the suit to be lingered so that they can continue.
How much time they can linger?
No, kindly do not give them 1 day also. And the reason I'll tell you, Lordship, why. Kindly takes a look at page 184. 183. This was their application, why they opposed. Kindly see 183 first. This is the prayers. Prayers have been set out.
Yes.
Leave be granted to serve a copy of the application on the purchaser. Then B, leave be granted to produce necessary documents with regard to such and such proceeding. Case number such and such. The necessary directions be passed not to give effect to the order dated such and such. So they only want that orders be not given effect to. Then D, an order be passed not to execute or convey the property in favor of Kamlesh Sharma. Different property, different state. E, an order of injunction be passed restraining joint receivers from depositing the money into the bank account. F, an order of injunction be passed upon Kamlesh Sharma not to deposit the money.
Yes, can you file affidavit before vacation?
We'll file it before the
record.
Mulad will kindly hear me out.
I will just
they don't have a locus.
Respect your lordship.
He's a partner. Undoubtedly, he's a partner.
His predecessor in interest was a partner.
Yes.
They did not less than 1% in the total share. They did his father or his predecessors did not oppose this, did not file written statement. Nothing is on record. So, Mulad, there is a decree on contest.
Embargo.
There is a decree on consent by his father. He cannot today come and
regarding sale.
Regarding sale,
yes.
Regarding sale, he cannot oppose. If the plaintiff and all the other 99% owners want sale, 1% opposes, we'll keep the money aside.
They want to bring some documents in the record. Let me see what
documents aside. We'll keep the money aside.
Okay, learned advocate for the applicant petitioner, Mr. Gupta, learned advocate for the petitioner plaintiff is present. Mr. Learned advocate for defendant number.
Various defendants.
Defendant number?
Holding more than 50% share.
Your defendant number?
Various. There are so many defendants.
Okay, learned advocate for defendant number 9A,
9B,
and other defendants are present. Learned advocate for the defendant number 9B intends to use an affidavit to oppose this application of the petitioner for sale of the suit property, which is objected to by the learned advocate for the plaintiff. But however, in the interest of justice, the court wants to see as to the nature of interest of this particular defendant in the suit property. Thus, an opportunity to file affidavit in opposition is granted till.
But you will just grant me 1 week time, I'll file it.
Yes. By 22/5/2025. However, no extension of time will be granted. It is made clear. Reply by, on the reopening date, you file your reply?
3 more days, my lord. I will not be there.
No. 23rd, the court will close for the vacation.
Yes. So, my lord,
On the reopening date of the
3 more days after the reopening. That is what I was saying.
Okay. Reply, if any, by 11/6/2025. Let this matter appear on 12/6/2025. It is hereby made clear that no further adjournments will be granted.
Great. May I file the affidavit of service?
Yes, let the affidavits, well, that is what affidavit regarding?
Affidavit of service.
Affidavit of service file be kept with the record.
Extremely grateful to you.
May it please, my lord, this is my application for being intervening and for being examined pro inter suo, my lord, in a suit of 1987. The last occasion, my lord, directed me to serve afresh, my lord, upon the parties, my lord. All the defendants, my lord, are represented. However, the plaintiffs, my lord, are not represented. I have effected fresh service, my lord. The advocates who had been representing the plaintiffs, my lord, are not traceable, my lord. So we have effected fresh service directly upon the plaintiffs, my lord. That is awaiting. My lord, the defendants are all represented.
Service is complete upon the
My lord,
plaintiffs.
that service, my lord, the second set of service pursuant to my lord's last order, my lord, that is pending, my lord. The first set of service, my lord.
No, second set.
Second set is pending, my lord. On the plaintiffs, only on the plaintiffs, my lord. The defendants are all represented.
So let it be adjourned after vacation. You just wait.
My lord, first tranche of service, my lord, has already been completed, my lord. Those affidavits are before my lord, my lord.
The advocates could not be traced out. That is why service is necessary upon them.
Very
Let
well,
them
my lord,
know.
that is-
It's an old matter, perhaps, my lord. That's why, and it hasn't been appearing in the list. The suit has not been
For a
coming in the
substantial
list.
period of time.
Perhaps that is why. I don't really oppose the application. The defendants aren't affected. I don't oppose the application. I appear for the defendant number 4, who's the owner of the property.
Number 1, 2, and 3. 1A, 1B, 1C, 2 and 3. I'm also not opposing the.
Anyway, record an order. A learned advocate for the applicant, Mr. Sen, learned advocate for the applicant, intervener is present. You are so all the defendants are represented.
Yes, my lord.
Learned advocates representing the defendants are also present in court. However, as service report with regard to the plaintiff is not yet received, the matter stands adjourned till. Yes, I'm keeping it on the reopening date 9th.
Very well, my lord.
On 9/6/2025.
My lord, the affidavit of service, my lord, pursuant to my lord's last order, my lord, that may
Let
be
the affidavit of service file be
It's
kept.
not
with the
complete, my lord, but we have attempted, my lord, to serve, my lord. That is
to get some report, you file it on the next day.
very well, very well. Grateful.
Twenty-four, my lord, I appear for the petitioner. We had filed an implement application. My lord remembers on the last occasion, my learned senior friend had filed a supplementary affidavit. We will seek a time, my lord, to file a reply to that. We have
You are appearing for?
The petitioner. I'm an intervener seeking to intervene.
GS16.
Yes, 16.
GS16, your
GS16.
application.
My application,
So
intervention
affidavit in opposition is filed.
already filed.
I tell you,
Reply.
Opposition reply is complete. My lord, in reply, they have got some new amendments and new documents. So I have to file a supplementary evidence. It's totally a imposter application, my lord. It's a suit of 2010. I'm not in the way, my lord. If they want to file a rejoinder,
I am only seeking some time.
Only thing is, my lord, the original plaintiff is expired, then substituted. It's a undefended partition suit. Now they are coming as a total imposter, my lord. I'll show you, my lord, is all the documents are false. Well, kindly tell me there's very short time to file the rejoinder and fix
They
it.
had filed a supplementary affidavit with leave of my lord earlier
Yes.
this week. I'm just seeking some time to file a reply.
Learned advocate for the applicant, intervener is present. You are for the plaintiff.
I am for the plaintiff, my lord.
Learned advocate for the plaintiff is also represented. Learned advocate for the applicant seeks time to file rejoinder to the supplementary affidavit filed by the plaintiff opposite parties. Such time is granted. Let this matter appear on 9/6/2025, reopening date.
My lord.
In the meantime, my lord, they file the.
Yes, in the meantime, yes, you are filing.
We'll give him give my learned friend an advance copy as well. We'll file it on the return.
On the reopening day, my lord.
Yes, reopening.
I'm grateful, my lord.
Deeply obliged.
One motion. Item number 25.
In this matter, my lord, I am happy. Yes. In this matter, my lord, I am appearing on behalf of the petitioner. I have preferred an application for addition of parties, your lordship. I am.
Applicant intervener.
Yes, your lordship.
May I file
Yes,
my? I appear.
In this regard, I am.
For my lord, the receiver, joint receiver. May I file my
You are
affidavit?
for the joint
Receiver, my lord.
Who are the joint receivers?
My lord, Mr. Subhash
No,
Bhattacharya.
no. Receivers are the from the bar or from the parties?
From the bar.
Bar, your lordship.
Lord, I am for the subtenants who are occupying the room. The
No. Who is representing the plaintiffs?
My lord. Plaintiff needs to be here, my lord.
Yes, your
We are
lordship.
seeking an order for, my lord, addition of party in the suit.
The
Have you served the plaintiff?
Yes, your lordship.
All the defendants are represented. It is a suit for?
This is a merely lordship. This is a partition suit, your lordship. And in this matter, I have preferred an application being a tenant in respect of a room number 27, your lordship. I am the necessary party as well as a proper party to this suit, your lordship.
So you served once again this plaintiff's advocate and the plaintiff.
In my affidavit of service, it is very much apparent, your lordship, that I have duly served upon the learned lawyer for the plaintiff, your lordship. It is served by hand, your lordship.
You have served all. এই ইয়েটা দেখি নোটিস অফ মোশনটা কোথায়? হ্যাঁ, নোটিসটার সাথেই আছে। No, plaintiffs are not represented by any advocate.
Yes, your lordship.
So you serve the advocates of the
Yes,
plaintiff.
your lordship.
Yes.
My lord, one more thing, my lord, pursuant to your lordship's direction, my lord, I have prepared my affidavit in opposition. May I file it?
Learned advocate for the applicant
And
intervener.
your lordship, in this regard, on the last occasion, we have also filed our reply, your lordship. It's on the record, your lordship.
Okay, learned advocate
On the
for the applicant intervener.
In the department, we have filed.
A learned advocate for defendant number 1 and 2.
Yes.
1 and 2.
No.
Learned advocate for the joint receivers are present.
Reply is there.
As none appears on behalf of the plaintiff,
It is
the applicant is directed to cause
Yes.
service upon
Oh, it is not open.
the learned advocate for the plaintiff, who is representing the plaintiffs in this case, to serve the plaintiff's advocate.
As your lordship desires.
Let the matter appear, my lord. The matter.
Let this matter appear on 10/6/2025.
10th. I'm grateful to your lordship. I'm grateful to your lordship.
It's my application. Lordship was pleased to take up this matter and passed an order on 30th of April. Lordship, because the defendant's application in the suit, where the receiver was there, receiver is holding some money. Now that application, now we say that the plaintiff is no more interested in the proceeding. The receiver is holding a substantial money in his custody. Now this money be paid to us because the plaintiff's claim has been satisfied. A specific performance claim of the plaintiff. My lord's last order records that we could not serve the plaintiff because the address was not available. Because we attempted service in 2 addresses, we failed.
Yes,
So we found out,
the address which you ascertained subsequently.
Yes, we served, delivered. The email ID, it is delivered. The email ID, even in the postal by the India Post, is delivered. The track report shows delivered is in the Theatre Road. This is the of the theatre, the affidavit of service. So, and so we have served the plaintiff. Now the receiver was, I believe, I don't know.
Lordship, on the last occasion, kindly sees the order of 30th April 25 at
Yes.
paragraph 3, second page of the order.
Yes.
My lord, the receiver was requested to, my lord, file the report
Because yes, submit the
regarding the
report.
money that is lying.
You have already filed.
I am the receiver, my lord. May I file the report?
Yes.
And if your lordship grants me leave, my lord, may I give a copy to the.
Yes.
Obliged. Well, what subject to what's falling from my Akula. I will see. না না কত টাকা আছে
5 কোটি
my god
হ্যাঁ,
মানে it's-
50
we are,
লক্ষ
we are missing on the
plus
figures yeah, that
plus
is
6
but
lakhs you will get it,
what I find from the page 5 of the report which is from the Standard Chartered Bank the principal sum is around 5.5 crores
5.
page 5 man. This is that's the best thing I should look into man. The deposit confirmation
Principal sum is
is 5 crores 5 crores 50 lakhs
Lordship will see the
33,490.
yes with the interest
and the interest, my lord,
interest.
on maturity that is on 23rd of
6,45,000.
June, it
Right.
will accrue
So-
6 crores. If it is encashed beforehand, it will be slightly less.
whatever it is
Principal
compound
sum is around 5 crores.
That is 23rd June,
Yes,
the date of maturity.
almost a month away.
oh 23rd June is just
Knocking at the door.
is knocking at the door it is knocking at the door subject to what my lord is thinking my lord, because today we are claiming this money back now the plaintiffs are not appearing now if observation from my lord in today's order that in the event they don't appear order will be passed to pay off the money because I don't know because this money I am taken and the suit will be decreed or disposed of.
No, you appeared for the defendant.
Yes, I'll tell you that.
And this amount was deposited on what account?
Yes. I appear for the defendant.
Yes.
There was an advance license. But she will see who are the defendants. I am I am Rashtriya Ispat Nigam Limited.
Yes.
The government of India
Yes, government
company.
undertaking.
Yes, government of India undertaking.
Yes.
We issued or we sold some advance licenses as per the then policy of the India government
Yes.
for export benefits.
Yes.
So these licenses, some of these licenses were purchased by the plaintiff. Then some dispute arose. This specific performance suit was filed for enforcing that license. During the pendency, an injunction was passed on me not to dispose of this license to be kept on hold because of specific performance suit. It was a duty-free advance license for importing goods, whatever. Now, in the passage of time, the license has a period. The license period was expiring. Unless we deal with the license, it becomes zero value. So, liberty was given to sell those licenses to market.
Yes. Which page of that order?
My lord. Lord, you will see the order. This page 14 this is the application. But all orders are not with us because I don't know because whatever the change
That
for us.
would be easy.
All orders are not available. You will see page 24.
Relevant orders at least.
Yes, I'll tell you. Rashid. Page 24 is in the application of the defendant where we sought for vacating and setting aside of the 2 orders by which the injunction was granted.
Yes.
Now, then the receiver sold the property. I have made pleadings because thereafter on this application, she will find page 27. Page 27 is the application filed by my client, a second application.
Yes.
Where we have prayed. Actually, the prayer portion is at page 38. The order be modified. The same. সবই একই জিনিস অ্যানেক্স করে গেছে একটার পর একটা no orders are with us তিনবার অ্যানেক্স করেছে একই জিনিস now I get a letter from the receiver at page 54 because the orders are not with us man. That's I have a basic reading no yeah. Now This letter which comes from the receiver at page 54, 2018, this records that some money is with the receiver, and then
This is the certificate, this is the investment made
yes,
by
this is
the
the
receiver.
investment made. Now, to get hold of the orders, my lord, it is
Now the question is, if the suit of the plaintiff goes, so all interim orders will be
or automatic. But the
Okay.
interim order is already any even modified because the injunction is not there because the property has been sold.
property has been sold.
Yes, and the money he has paid to us has been given back. Specific performance suit. The
Yes.
plaintiff must have paid some money to us.
Yes.
That has been returned to them. That's my
Yes.
specific
All
case.
these things have to be stated in the orders and list of dates.
My lord, then I know, but we are handicapped in that extent because the suit is a 1998.
Yes.
It was initially SN Sen and Company. That office has closed down.
How many orders you have annexed, you see?
No, I have annexed no orders. I have annexed no orders.
Because you see those
The registrar may help
of
us.
the order, this sale of the property.
I know. I have pleaded.
We
I
have
have
to-
pleaded.
We have to come to the conclusion.
Lordship, and that even what passing.
Because you see, you have what you have prayed, you see.
Yes.
The entire thing, you have to take back the money, the receiver has
Yes,
to be
yes.
discharged, all this thing, huge amount is involved.
Yes, huge amount in.
So better you
I'll tell you, Lordship, the difficulty we are facing now is in 1998. If some order of my lord with the registrar, original side, because the court of records, he must be having all records. Some records be produced in connection with this suit and the orders passed. Because 1998, even if I apply for
Two applications in the bank's advice, the lordship will see that the numbers of 2 GAs are given. At least those 2 GAs should be produced and all the orders passed therein.
Lordship will kindly come to
passes
paragraph 10 of my petition.
Expedite the process. Lordship,
Pleading.
admit. Lordship comes to page 5, my lord.
Page 5.
না এখানে GA number দেওয়া আছে।
Down.
Paragraph 5.
No, page 5.
Yes, page 5.
The deposit confirmation advice. Lordship says re-deposit number.
No.
In the name of
page 5 of GA9.
No, my lord, it's showing report. Today's report.
Page 5 of
the special officer's report.
GA number গুলো দেওয়া।
Receiver's report, my lord. Page 5.
Yes.
In the bank's deposit confirmation advice,
Yes.
lordship sees re-deposit number such and such in the name of such and such receiver in CS number J4059 of 98 and 4524 of 99. So these 2 GAs should be produced and the orders passed there.
40456.
4059.
4059.
But we
456 is the CS number. That's the suit number.
And 4524.
Yes, these 2 GAs should be produced and the orders passed therein. Then your lordship will get a clear
Yes,
picture of what has happened.
The chain of events. Lordship, I have made the pleading, paragraph 7 of my application. Paragraph 7 of my application, the specific.
So if your lordship passes an order that this to be produced by
There's
the
reference in the order.
It has to be. Because, we are not getting. না না সে রেজিস্টার অরিজিনাল সাইট বুঝবে
because if we go
no
it will take substantial time.
1998
advocate for the defendant petitioner and Mr. Dotto, learned receiver, is present. None appears for the plaintiff in spite of service. GA 9 of 2024 is taken up for consideration. Hard learned advocate for the petitioner defendant. It appears from the petition that relevant orders passed in GA 4059 of 98 and 4524 of 99 is not available is not annexed to the petition, nor is it available in the record. Thus, the registrar original site is requested to put up GA 4059 of 98 and GA 4524 of 99 along with the relevant order, along with the orders passed in these 2 applications
in connection with the instance suit.
In connection with CS
yes,
456 of 98.
My lord.
By 11, let it appear after vacation.
Yes.
11/6/2025. Let this matter appear on 13/6/2025.
My lord, once the records are produced,
Yes.
we may be also requiring a copies thereof. If the observation or
Okay,
direction.
you can take inspection and they let the records come first.
11th July.
Yes, yes.
Yes, it
11th
takes-
of June.
June. Sorry. It will take some time.
Yes,
For
yes.
the registry. Because 1998, if we go, no chance
Wait
of
for 1 month. You have waited for so long.
the interest is increasing.
Yes, yes, yes.
And even the
It will come here.
Lordship, kindly record that I have filed my report.
Okay.
affidavit of service is fine. I have filed affidavit.
The affidavit of service filed by the petitioner defendant and the report filed by the learned special officer
Receiver.
be kept with the record.
My lord. Lordship. My lord.
Item number 27, Meenakshi, Nadim and Rajnish.
For the substituted defendant number 1A and 1B.
Yeah, my lord.
Item 27, you are appearing for?
For the plaintiff.
Yes.
This was suit made for 75 lakhs and not, my lord.
No,
There, my lord,
GA5 is whose application?
my lord,
is
that
our
GA5
application.
is pending, my lord. That is their application.
Yes.
They now asking for extension of time to file written statement. Now, my lord, in that, my lord, we had paid for an opposition, my lord.
No, GA5 of 2025.
Yes, my lord.
So, this application is to be heard on affidavits.
Yes,
So,
Yes, my lord.
yes, my lord.
My lord,
But
on
I
the
am
last
bringing
occasion.
extension of time to file an opposition, my lord. But I have the
My
plaintiff.
lord, on the last occasion, that is on 22nd of April, my lord,
First we are
please to
directed
grant them leave to file the opposition.
how much is the delay in filing the written statement?
Now, my lord, the thing,
My lord,
delay is, my lord, is quite long, my lord. 2011 suits, my lord, and 2025 asking for filing written statement, my lord. Delay is long, my lord. So, my lord, our opposition should have
Yes,
to
record
come
an
on.
order. Learned advocate for the petitioner defendant and learned advocate for the plaintiff opposite party.
My lord, we are the substituted defendant number 1A and 1B.
Okay, learned advocate for the defendant number 1A and 1B and learned advocate for the plaintiff are present. Learned advocate for the plaintiff opposite party prays for time to file affidavit in opposition to GA5 of 2025. Such prayer is allowed. Let affidavit in opposition be filed by 10/6/2025.
10/6.
Reply, if any, by 13/6/2025. Let this matter appear on 18/6/2025.
তোর এও কবে দিল
10/6.
10/6 10/6
আচ্ছা 10/6 10/6 এটা হচ্ছে 13
এক মিনিটে হয়ে যাবে 31 না কত
Item number 31, so Moti Devi.
এক মিনিটে succession.
My lord, 31, my lord, I was appealing for the respondent in this application. My learned senior, only one thing I would like to indicate, my lord. He files an application for intervention in an application, which is, my lord, not in the list. If my lord kindly tags those two applications together and takes it up for you.
GA25 is your application.
GA2
GA2 is
GA2
for
of 2025 is your
is
application.
for intervention in GA1, which is my application.
I am not, I cannot stand in the way of this.
My lord, let
request
two
to- my lord.
applications be taken.
Like, if lordship's pleasure, I can say in brief what I am doing.
You have served copy? Oh,
Yes, I have served copy.
My lord, no copy has been served on me, my lord. I am also an interested party so far as this estate is
Me
concerned.
No, interested party, have you filed application?
No.
So how can you show your interest?
My lord, this is an application. I don't know. One of these applications, my lord, is an application for revocation of probate.
Yes.
Possibly
That is
GA1.
mine GA1.
Now, so far as this probate is concerned, my lord, I am deriving rights, my lord, based on this probate.
Neeraj.
I am, my lord, appearing on behalf of Mr. Neeraj Khanna. Whom Mr.
I'll tell you, my lord, in brief.
So he has to
To some extent, I will serve. To some
If you
extent,
want
I am
to
Mr.
put in
Medar.
the record, if you want to intervene by way of application, you file your application.
I also serve a copy of the
How can I
application.
serve? You're
only.
not a party yet.
Now, at present, because that revocation application is filed,
Yes.
so definitely you have some interest.
Yes, so therefore I need to know what has been stated in the revocation.
No, I'll tell you the difficulty.
Neither of these two applications
If
have been
my lord,
submitted.
if my lord passes,
Testing other proceedings
is-
before this court.
if my lord passes an order, I have
So
to
in the
serve.
original, So in the original applications, you were not a party, but your predecessor was a
My
party.
predecessor was a party.
No, no, no. He's a third party to the family. Well, I'll tell your ship.
I am claiming my rights on the basis of a will executed by one Mr. Anirudh Chamriya. Mr. Anirudh Chamriya's father had obtained the probate of the will of
Okay,
Devi.
then you better do one thing. File your application with a short
Application,
cost title.
yes.
File that application.
So
No
file your
difficulty,
application with a.
But
I'm
kindly,
keeping
my
it
lord,
after vacation. Do whatever you want in the meantime.
kindly also direct them to serve the copies of these applications.
Let
only
him,
in
let
the
him
meantime.
file an
File a
application, establish
application
his
with a
right.
short cost title, stating your rights. Thereafter, if necessary, directions will
Very
be
well,
issued.
I can do that.
Yes, item.
And in my application, when they want to use an opposition, that can be done.
Not an opposition at this matter. Let GA2
Item
and
31,
GA1 be taken
let
up contract.
GA1 of 2025 appear along with GA2 of 2025
Neeraj.
on 10/6/2025.
After vacation.
10th of June.
My lord, any day apart from the 10th of June, man. Any day. I'll take it to my lord.
Maybe 1 week after holiday.
Okay, 16/6/2025.
I'm so
Yes, 16 June.
I'm so good.
66.
Grateful. Yeah, application করবে।
তিনটে fixed matter.
Item number 20 is at PPL for the commercial 28 to 30.
They were to give reply on the points
Yes,
of
yes,
law.
yes. Let them give reply. Let it be concluded.
Bye.
Your Lordship,
Yes.
in essence, Your Lordship, there are 3 or 4 points that have been taken by the learned senior opposite in order to oppose my application, in order to support his application. As Your Lordship,
রেকর্ডটা দিন
GA3, GA4 দুটোই দেবেন।
GA4 is your application.
GA4 is my application for extension of time to lodge.
Now we are hearing this GA3 and 4.
3 and 4 together. Yes.
I'm like,
I have
third
made
point.
submissions also on GA3 and 4 together.
I've made submissions on GA3, 4 together, sir.
Anyway, you are giving the reply now.
I'm just giving the reply on the point. So, my lord, the first point that my learned senior takes is that that we as office bearers cannot deny this because we are the new committee of the respondent association. But that previously, when the previous application in 2012 was moved, my lord, then, my lord, the plaintiff had a different management. Thereafter, there's been a change. The defendant also had a different management. The plaintiff also had a different management. One, Mr. Badri Prasad Agarwal, used to look after the litigations of the plaintiff company, who passed away in 2017 or 2018, if I'm not mistaken. So therefore, there was a change in management. There was a change in the advocate on record. And it was subsequently discovered. Because earlier, the plaintiff had not been advised appropriately on the requirement to lodge the writ of summons. And that after the change in management, it was discovered that the writ of summons had not been lodged. It is my learned senior's contention that previously, during the hearing of the previous application, the counsel for the respondents in the previous GA, that is GA number 1929, which came up for hearing on 27th August 2012, the plaint had been handed over to them. My lord, I say first and foremost, I have already addressed these points when I was making my argument. And my lord, my learned senior contends that because the service was affected, we had waived the formal requirement for the service of the writ of summons. And he also contends that we've kept quiet for the last 12 years. And that therefore, it shows that we have had the plaint, or we've been given the plaint. And therefore, my lord, the delay should be read as against us and not against them in bringing the application for dismissal of the suit for non-filing of writ of summons and non-service of writ of summons. My lord, I say first and foremost that there is the convention in the original side that whenever service of any document is effected by one advocate on another advocate, then it is placed under a covering letter sent by hand service through the clerk of the advocate on record who is effecting service of that document. The clerk of the advocate on record carries an office copy of the letter, and my lord, the endorsement is made on the office copy accepting service.
May I make one humble submission? Since my lord, he's in reply, my lord, shouldn't he confine his arguments only to points of law and the
he's
judgment?
clarifying the position. Okay, whatever you have argued, that he's
That
clarifying.
he had initially done. Factually, otherwise this will be a never-ending.
From your side, okay.
My lord, very simply, I'm saying that they are saying that service was effected upon you. I'm saying that I have already said that service was not effected upon me, and I'm saying that the legal threshold that is required to be fulfilled to show service upon me has not been fulfilled, because there's nothing on record to show that service was effected upon me. And I say, my lord, that service was not effected upon me. And I've already stated in my affidavit that had service been effected upon me, then, my lord, I would have been sure to file the written statement. Why would I have waited so long? I take your lordship back to my application GA number 3 as to the delay.
No, regarding the stand of the UCs, regarding their stand, that yes, the copy was handed over. Your stand, it was not handed over.
And they have given no proof that it was handed
over. No proof. Yes, you just address on these two aspects mainly.
Yes, my lord. I'm simply saying that the convention that is there for service,
formal service,
or for that matter, informal service, there'll always be a proof. The fact that there is no proof goes to show that their contention that they effected service on us is not believable.
My lord, may I take your option? My lord,
And as I have shown your lordship previously as well, the plaint was never annexed to any of the applications. That is a matter of record, your lordship. I'll not again trouble your lordship with the page numbers. I'm just taking your lordship to page number 65. Because they say, why were you waiting so long? Of my application, GA number 3.
65.
At the risk of repetition, your lordship.
Okay. Yes.
The online searching that I carried out in the website of the High Court. Up till 31st August 2020. My lord, case number 241, year 2012, that's the suit number. From 8 July 2024, as I had shown your lordship, on 7th July 2024, their previous application was dismissed for default. And up till 31st August 2020, 1st September 2020, the CIS system came into existence and was implemented. So, my lord, no record found. So, my lord, the reason I couldn't bring this application earlier is because there was no activity in the suit. Had there been the carriage of the proceedings lies with the plaintiff, your lordship.
Regarding interlocutory applications, you appeared.
Yes, I appeared in the interlocutory.
Interlocutory application.
Yes, your lordship. I appeared in the interlocutory application. Page number 64, if your lordship sees. The previous interlocutory application.
So this one you appeared.
Yes, I appeared.
And this interlocutory application was dismissed.
For default.
But the suit was not dismissed. Only the
suit was not dismissed.
Anyway, this is in 2014. Okay.
Yes, your lordship.
This was the dismissal for default. You searched when? 2020.
From 8 July 2014 up to 31st August 2020.
Yes.
In the website of the High Court, not in the CIS system, your lordship. In the website of the High Court, no record found, which indicates that no steps were taken. So, my lord, my learned senior friend keeps relying on the judgment of the division bench in NPR Finance to say that delays should be excused. However, my lord, as I have shown priorly, there's a paragraph in that judgment which my learned friend is also my learned senior friend
up to 2014,
from 2014 to 2020, no record found, no steps taken by them. They have been an indolent.
So this search was caused in 2020.
Yes, your lordship. 31st August 2020. Search wasn't caused, the date parameter was entered from 28 July 2014 to 31st August 2020.
Yes, and this system came into existence in 2019.
2020, 1st September 2020, CIS came into existence. I'll show you the CIS, I'll show you, Lordship, the CIS search as well, at page 68.
I have not denied that I've taken any steps. Why is my learned friend harping on this? I've said I've not taken any steps from 2014 to 2020.
Whether he was aware about the suit being filed.
He's not saying he's not aware.
I
He
was
has
very much
contested
aware.
the interlocutory proceedings.
Yes, yes.
Which
That is an admitted.
Your Lordship has seen the division bench. It says if he's otherwise aware of the
No,
proceedings.
no,
that is
it
not-
is an admitted position. He has appeared in the interlocutory proceedings. Interlocutory application was dismissed, but the suit was kept
So
intact.
he's aware that there is a suit.
Yes.
I'm
So
not
no,
saying
what is your contention that he has not?
That I should have brought this application
No,
earlier.
not demanded any plaint from you. Demanded.
Neither demanded any plaint, nor has he brought this application before, which means he had the plaint.
Which means, my lord, that I
And-
didn't have the plaint. The onus is not on me to demand the plaint.
And the
The onus
honorable,
is on them to serve the plaint
honorable
upon me.
division bench has categorically held if the defendant is otherwise aware of the proceedings.
Anyway, just
That is what the
Why
onus
is
of
it-
the division bench should
this is an admitted position.
CIS, this
No,
thing,
no, this
let's
is
see
admitted
if you take
position.
any steps.
You appeared in the interlocutory court. Interlocutory application was dismissed, but the suit was intact.
Yes, the suit was intact, your lordship.
And it's still
What I'm
intact
trying to
today
assert
also.
By showing these records, what I'm trying to assert by showing these records, your lordship, is the fact that the plaintiff has been the indolent litigant. It is not on me to bring this application because of their delay. It is on them to not make a delay in the first place. It is not on me to demand a copy of the plaint. It is on them to serve the
You
copy of the
filed
plaint
this
upon me.
application in 2020.
24 after my
2024
second
in
application.
GA, when they filed GA number 2 of 2024, seeking
At Mr. Tiwari's
interlocutory
Okay,
release.
so you
After
obtained
that,
it.
your lordship.
So this is
Huh?
on 2020. You filed application on 2024.
After my second application.
After their second application, suddenly the
They
suit
were sleeping
revives.
also.
Suddenly the suit revives. The point is this: my lord, I sit in a castle. The plaintiff comes and attacks me. If the plaintiff doesn't come and attack me, I cannot send out a signal saying, "Why aren't you attacking me?" That is what I'm trying to say. That they never took any
But
steps.
you
So how
know
could I
that
be aware?
but there is you knew about that there is a signal. Anytime there can be attack.
Yes.
Signal is there.
Certainly, your lordship.
Danger signal is always there.
Anytime it can.
Danger signal was there.
But
what is
but
the
you-
conduct of the danger
But
signal?
for the time being, you kept quiet. You know that there is a danger signal.
He was
Absolutely.
enjoying also.
There is a danger signal. What is the conduct of the danger signal? Dismiss for default.
Very well.
Costly
That suit is still there. Subsequent. Anyway, after 4 years, you filed this application.
But my learned friend said his cost is the panacea. He has said that in the division bench, cost has been
Anyway,
avoided.
let him conclude.
No, I didn't say the search was not carried out in 2020, your lordship. The search was carried out in 2024. The date was
2024.
After the interim order was.
Start date of search, end date of search.
So this is carried out when?
In 2024.
Page 65.
Yes, your lordship. In 2025.
Page 65.
The data I entered is of 8 July 2020, 8 July 2014 to 31st
No,
August
page
2020.
65. No, page 65 is 2024.
Yes.
Okay.
Search carried out in 24. Search till 2020. Page 68, the CIS search, your lordship. If your lordship, I wish to access any records or judgments or orders of this honorable court that prior to 2020, prior to 1st September 2020, then I cannot look it up on the CIS. I'll have to go to the High Court website. If I have the precise date of the order, I'll enter the precise date of the order with the matter number. Or if I want to...
This is from the period 2014 till 2020.
Yes, your lordship.
And the search carried out in the year 2024.
Yes, your lordship. Page 68, search carried out from 1st September 2020. Page 68.
Yes.
Search carried out from 1st September 2020 till the date of, or just prior to the filing of the application.
Yes.
The onus of taking steps is not on me, is what I'm on, your lordship. The onus is on them. They are the ones who have to be the diligent litigant because the carriage of the proceedings.
If they have not taken and they could not justify, they have to suffer.
They have to suffer. Absolutely, your lordship. Absolutely, your lordship. So that is the essential main point that is taken by my learned senior friend.
Division based distribution.
Give me a moment.
What will that mean?
The other contention, Your Lordship, is that they weren't aware of the requirement to file the writ of summons, and their contention that we've paid 50,000 court fees and we have instituted this suit, so we gain no advantage out of filing the writ of summons.
Not filing.
Out of not filing the writ of summons. Your Lordship, my answer to that question is very simple, or that point is very simple. My answer is this, that the requirement to file a writ of summons, as is apparent from all the judgments that I've already placed before Your Lordship, the requirement for the writ of summons is this, that I get notice, and not just of the existence of the suit, the cause of action in the suit. Because with the writ of summons comes the plaint. The plaint was never annexed to any of the interlocutory applications. So, until the service of the plaint through the writ of summons is carried out on me, I cannot answer the cause of action. So, it's not about the advantage that they have gained. It's about the disadvantage that they have put me in, which is that I have not been able to contest the suit despite its pendency, because the plaint was never served upon me.
So regarding filing of Vakalatnama, that was done with regard to interlocutory application only.
Your Lordship will be able to see from the record that for every interlocutory application, we have had to file separate Vakalatnamas, because we cannot file a Vakalatnama in the main suit. I had shown Your Lordship the original side rules, wherein once the writ of summons is served upon me, I have to return the writ of summons and file my Vakalatnama along with that to enter my appearance in the department. Otherwise, I have to take special leave from Your Lordship to be able to enter appearance. But I cannot enter appearance in the main suit until and unless I return the writ of summons. So that is why for every interlocutory
Code of Civil Procedure permits that appearance without summons. So where Code of Civil Procedure is concerned.
Yes, Your Lordship.
The defendant can appear without writ of summons also.
Yes, Your Lordship. So long as I take leave under the original side rules.
Yes, but you have to obtain leave.
Absolutely, Your Lordship. Again, since had I been served with a copy of the plaint, I would have taken such leave and entered appearance and filed my written statement. Now, Your Lordship, these are the factual contentions that have been advanced by the other side. Just on the law I am now.
You have taken the relevant points of law in your written notes, probably?
Yes, Your Lordship.
Yes.
I have. Now, as far as the law is concerned, my Lord, this special bench judgment was cited to Your Lordship, the unreported special bench judgment. It was handed over to Your Lordship on the previous.
It was given in the compilation.
No. Separately, we had handed over two judgments, both NPR Finance, the division bench, and the special bench. Both were handed over.
Okay. Yes, what do you say with regard to that?
With regard to the special bench judgment, Your Lordship, what I very simply say is this. There, the question before the bench was, what had happened in that case was, a division bench had found that it was that the learned single judge, whose judgment was in appeal before the division bench, had found that the learned single judge had perhaps departed from a previous learned single judge's order. So in the appeal, the division bench asked itself whether there has been some violation of the system of precedent, or whether the question of law that had come up in the case should be referred to a three-judge bench, and therefore it had referred the matter to a three-judge bench. The three-judge bench, the special bench, decided that the reference to it was infirm. In deciding that the reference to it was infirm, it quoted certain previous judgments in order to show that the division bench which had made the reference had already passed a judgment. So therefore, the reference was infirm. So, my Lord, the special bench judgment is not authority for any of the propositions that my learned senior friend cites. My learned senior friend argues that delays can be excused, or that the judgment in Turit Appliances of Justice Ajoy Nath Rai, which sets the limit at 3 years under the residuary article of the Limitation Act, that limit is ever extendable. That is not being held in this special bench. If I may show Your Lordship. Your Lordship, the first page of, has Your Lordship got this special bench?
Yes.
The first page itself. Your Lordship, the third sentence on the first page itself. the division bench also expressed its opinion on the legal issues that have been raised by the writ petitioner as well as the respondent. Ultimately, the division bench examined the propriety of the judgment of the learned single judge, which was in appeal, and thereafter observed as follows. Considering the above, we feel that the appeal should be allowed. However, the appellant must be penalized for their laches, and the defendant should be compensated with costs, which is assessed by us at rupees 50,000. After thus expressing a final opinion, the division bench proceeded to record as follows. Then after, my lord, there's the extract. I'm just reading the second.
How much days delay was there in this particular case?
My lord, the question of delay never came up in this case. This special bench, your lordship.
Yes.
So your lordship has the second page.
Yes.
So the extract there, the second of the extract, the second paragraph. Let this appeal, my lord. My lord has it.
Page 2.
Yes, page 2.
Yes.
Yeah, let this appeal be placed before the Honorable Chief Justice for constitution of a larger bench to decide whether the defendant had acquired any valuable right due to delayed service of the writ of summons and whether the court in the given circumstances was entitled to condone such deed. Then, my lord, this question was asked put to the three-judge bench. The three-judge bench's answer was neither yes nor no. The three-judge bench's answer was this reference is infirm. We don't have to answer it. Because, my lord, the contentions. Mr. Anindo Mitro, learned senior counsel with Mr. Obrijit Mitro, submits that the appeal having been allowed by the division bench, the reference was clearly incompetent. So, my lord, that was the contention. Now I'll show your lordship. Now, the third paragraph there, on the same page. We are of the considered opinion that there is merit in the submissions made by Mr. Anindo Mitro, learned senior counsel. As noticed above, the division bench has considered the entire factual aspects as well as the legal issues involved in the entire appeal. The division bench has even considered the propriety of the judgment rendered by the learned single judge. Thereafter, in the closing stage of the judgment, the division bench clearly observed that the appeal should be allowed. Not only this, the division bench proceeded to hold the appellant responsible for the laches and impose costs assessed at rupees 50,000. This apart, after making the reference as noticed by us above, the division bench clearly states the appeal is, however, disposed of at our end on the above terms. Now, my lord, the division bench's observations after that are quoted. We may notice here some of the observations. I'm not troubling your lordships by reading all of these many paragraphs. I will straight away take your lordship. Page number 5, your lordship.
Yes.
Page number 5, your lordship, the second paragraph of the main text. Yeah, having thus based its conclusions on the judgments of the Supreme Court, the division bench was bound to follow the same. That seems to have been the course adopted. At that stage, the appeal stood allowed. This is evident from the imposition of costs on the appellant. The reference seems to be an afterthought. So, my lord, the Honorable Special Bench does not even answer the question that is posed by the division bench. It says that this reference is already incompetent. We cannot enter into the reference.
What is the conclusion arrived by the special bench?
That's what I'm getting to, your lordship. Your lordship, the second last page, your lordship.
Yes.
The last paragraph of the second last page, in our opinion.
Yes.
In our opinion, a bare perusal of the extracts of the reference order reproduced above clearly shows that the division bench has marshaled the relevant facts, delineated the legal issues, and thereafter stated the conclusion. Thus, clearly, the division bench has delivered a judgment on the merits of the appeal. The next page. In such circumstances, we are constrained to observe that the present reference is incompetent. So, your lordship, the reference, the question therein of whether delayed service of the writ of summons has led to a valuable right accruing in favor of the defendant was not answered either as a yes or a no. So, this cannot serve as authority either to support me or to support my learned senior friend's contentions. So, that said, your lordship, I come finally again back to my notes of arguments, your lordship.
Anyway, that you have argued.
I've argued.
Anything else? Clarification from the oppositions which
So
which
main-
is submitted.
Distinguish the main division bench judgment.
That's what I'm coming to. That's what I'm coming to.
টা বড় বাবা।
আরে ওটাই তো করতে চাইছি।
বড়। Notes of argument এ চলে গেল তাই। স্পেশাল বেঞ্চে এত পড়লে না। ডিভিশন বেঞ্চে একটু মন দিয়ে পড়ো।
Your Lordship, the page 19 of my notes of arguments, Your Lordship. The same division bench judgment I am also placing reliance on. Page 19 of my notes of arguments.
ছয় double. I'm now very eager at this moment.
Page 19. Yes.
Video recording হচ্ছে।
Lordship.
Yes.
Lordship, I'm being teased, Your Lordship.
Anyway.
Word gesticulation.
We have carefully considered the pleadings filed before the Honorable First Court, the second paragraph, Your Lordship, I'm reading, and also the judgment and order passed by the learned judge. We are completely in agreement with the learned judge that the application is bald and sketchy. No convincing or credible explanation has been advanced by the appellant for its deep slumber over a period of 6 years. Purported reasons sought to be given are vague and unacceptable. However, for the reasons stated in our judgment, in APD 230 of 2010, we are inclined to grant an opportunity to the appellant to proceed with its suit, subject to it compensating the respondent with costs such as that rupees 5 lakh. So APD 230, the division bench refers to says that whatever reasons we have given therein, those reasons should be applicable here. So APD 230, Your Lordship, what was done by the division bench? Page number 18. We have gone through page number 18, Your Lordship, the third paragraph.
Yes.
We have gone through, it begins with those words.
Yes.
We have gone through the erudite judgment of the learned judge carefully. We agree with his lordship that the conduct of the plaintiff has been deplorable and highly unsatisfactory. Going into hibernation for 6 years after filing the suit is quite unsupportable. However, we feel that ends of justice would be subserved if rather than non-suiting the plaintiff, we put it on terms. We do not feel that such a prejudice has been caused to the defendant that cannot be compensated by awarding heavy costs in his favor. So, Your Lordship, the reasoning being that heavy costs should be awarded if someone has slumbered over their suit.
So, what is heavy cost will depend upon the facts of each case.
Certainly, Your Lordship. That Your Lordship, I cannot press on any authorities. That is Your Lordship's discretion.
Yes.
Because here, Your Lordship, it was 6 years in the case. That in the case before Your Lordship, the delay is exactly double of 12 years. And Your Lordship, finally, I keep heavily relying on this judgment. However, my Lord, I rely on this judgment merely because it really states the law and clinches the issue. Page number 24, paragraph 21. That's again.
This was considered. This was considered by the division bench.
It was considered by the
was laid down, but it was considered by the division.
It was considered, but the point herein that beyond 3 years.
Anyway, that is binding upon the court.
Yes, Your Lordship.
But yes, the division bench held in some exceptional circumstances, the court is empowered.
Yes, Your Lordship. I say, Your Lordship, those exceptional circumstances don't exist here.
Very well. That has to be considered.
That is now Your Lordship's discretion. Merely because I was there in interlocutory applications, because that is the holding in Torit Appliances, which, my Lord, the division bench has not yet considered. That would be it from my side, Your Lordship. I'm very grateful for a very patient hearing.
Okay, thank you all.
Given the notes?
Yes, record and order. Learned advocates for the plaintiff and learned advocates for the defendants have concluded their arguments on GA 3 of 2024 and GA 4 of 2024. Let this matter be treated as CAV. So written notes, the written notes of arguments filed be kept with the record.
By both
yes, you please check whether the citations are there or not.
Judgments are there,
Yes,
citations are there. I've quoted from the citation.
No, from the record. Just verify the record.
দেখুন তো দুটো judgment যেহেতু আমরা কালকে দিলাম।
Record.
Do we stick
এক্ষুনি
it
hand
with
up
the
করেছে।
notes?
It's better.
Yes, better.
And
I've made
mention
a
it, but
compilation.
yes, mention it just by the plaintiff or defendant whom. Otherwise, there will be
No, my
confusion.
lord, my learned advocate on record is here. She will stitch it.
And mention by plaintiff and from your side that by defendant.
দেখেন আমার নোটস দেখেন।
আমরা যেগুলো করেছি
আমাদের
আমরা
নোটসটা
সব-
দিন, আমি এর সঙ্গে স্টিচ করে দিচ্ছি।
Your Lordship, I have prepared it like this with an
Plaintiff
index
notes.
and everything.
Plaintiff and notes.
Okay.
And I've written, I'll just
Yes, if the decisions are cited in loose copies, then it is better to give state whether it is by the plaintiffs or defendants or whatever.
I've stated like this, notes of arguments of the defendant, Your
Yes,
Lordship.
yes, yes. And there is a compilation also. No, regarding
Yes.
the
All the
judgments are
judgments
also there.
stitched together,
Yes.
paginated as well, for ease of Your Lordship.
কোন দিনের আমাদের আমার সাবজেক্ট টু
আমারটা তো পুরো
26 মে বোধহয় এন্ট্রি মডেলটা এক্সপায়ার করে যাচ্ছে ডিউরিং ভ্যাকেশন
My lord, the interim order possibly is expiring on 26th of May. If your lordship kindly
Okay,
extends
the
after the
interim
vacation.
order granted earlier stands extended for a period of 3 weeks after vacation or till further orders, whichever is earlier.
Interim order in GA2.
Well, interim order in GA2.
Acha, the interim order granted earlier in GA2 of 2024 stands extended for a period of 3 weeks after vacation or till further orders, whichever is earlier.
Gratefully.
Yes, yes.
But in the course of today's proceeding, my lord.
Yes, yes, yes. Just check it up.
Yes.
Estimated matter starting from the 30th of March Chakraborty.
Yes, not today.
33 in the goods of Kopi Chatnahata.
Not today.
34 in the goods of Ashrafi N.
Not today.
Item number 35.
দেখি 35টা অর্ডারটা দেখি কি হয়েছে অর্ডারটা এসছে নট টুডে
Item number 36 garbage.
এটাতে আগে কোনো অর্ডার পাস হয়েছে 36 এ Yes, record an order. None appears for the parties when the matter is taken up. Stop. It appears from record that the matter appeared on 23rd April 2025, but none appeared for the parties. Stop. And the matter was adjourned till 14th May 2025. Today also, none appears for the parties. In the interest of justice, the matter stands adjourned till 17/6/2025 as the last chance. রেখে দিন এটা দেখি আগের অর্ডারটা কি হয়েছে
লক্ষ্মী দেবী নাতানি
$37. 37 or same as 36. Yes, 38.
38 লক্ষ্মী দেবী
38 টা রেকর্ডটা দেখি 38 এ অর্ডার হয়নি কিছু আচ্ছা 38 not today
39 সুস্মিতা ব্যানার্জি
not today
40 21st century
not today
41 GT and company
not today
42 Shiv Prakash Kajaria
Not today.
43 Virendra Sangvi,
Not today.
44 explosives division.
Your Lordship, I'm for the petitioner. I'm praying
You're
if,
for plaintiff.
yes, Your Lordship, plaintiff. I'm praying if it could be taken up sometime after vacation because there is a short
What
of
is the
electricity.
stage of the suit?
Your Lordship, the briefs are not available at this point because of the electricity issue at 6 Road Post Office. Our briefs are not traceable at this moment.
Okay, item
That
number
is why
44.
44 and 45, Your Lordship,
Okay.
both are.
Item 44 a record করুন order. Learned advocate for the plaintiff is present. Learned advocate prays for time to take necessary instructions in this matter. Let this matter appear on 18/6/2025.
Pleasure.
What is the Nawal Kishore Choudhury?
Forty-six is not today. Yes, 46 order টা দেখি কি last order.
মশাইয়ের কথা হলো তোমার অফিসে 14 তারিখ আসার কথা ছিল, ঠিক আছে? হ্যাঁ, তোমার অফিসে 14 তারিখ আমার মক্কেল কাছে যাওয়ার কথা ছিল, আজ কথা ছিল মশাই, সেটেল হয়ে যাচ্ছে। না হলে প্রসিড করবো কি?
Yes, 46 record and order.
আমরা মক্কেল কাছে আসার কথা ছিল।
None appears for the parties
হ্যাঁ,
when the matter is called. It appears from record that the matter was taken up on 23rd April 2025 when none appeared for the parties. Stop. However, in the interest of justice, the matter stands adjourned till
Okay, here we go.
19/6/2025 as the last chance.
Forty-seven.
47, I'm for the plaintiff. My
I'm for
lord.
the defendant.
My lord, this matter is, my lord, it is amicable settlement is process, my lord. It is hope, my lord, matter will be settled. Your lordship, my instruction to pray for 8 weeks time. In the meantime, it will be settled.
Yes, record and order.
Only your lordship kindly adjourn 8 weeks time for amicable settlement.
Learned advocates for the parties are present. It is submitted by the learned advocate that talks of settlements are going on. Thus, in the facts and circumstances of the case, the matter stands adjourned till 8/7/2025, 8th of July.
8 weeks. I have been
8th of
instructed.
July.
8 weeks. I prayed for 8 weeks.
Almost it is 8 weeks.
8 weeks. 8th of July.
Okay. 15/7/2025.
Very well.
State of West Bengal versus Calcutta.
48, Your Lordship, I appeared for the plaintiff. Your Lordship, on the previous occasion, Your Lordship directed to serve a notice on the defendant. I have served, but my
Defendant and his advocate.
my lord, there is no advocate. My lord will have a kindly look at the other earlier orders.
No, defendant has entered appearance
No,
in this
my lord,
case.
nothing. We had in fact cause substituted service for the service of the writ of summons. Thereafter, we also issued.
No, is there any order that the service is effected upon the defendant?
No, my lord. My lord, there is.
Whether service upon the defendant is complete or not, that is the question.
My lord, your lordship can call for a report. Your lordship. There was.
A report can be called for.
Yes, my lord. My lord, there was an order. Your lordship will kindly have a look at the order dated 9th May 2024.
9th May, yes.
9th May. Your lordship will kindly. Lordship directed paper publication. My lord, this has also been done.
Okay.
Lordship will kindly keep it after 2
9th May 2024. So, this paper publication was done.
My lord, right now I do not have the affidavit of service. Your lordship will keep it after 2 weeks after the summer vacation.
Yes, record and order. Learned advocate for the plaintiff is present. Learned advocate prays for time to obtain relevant documents in this case. The matter stands adjourned till 18/6/2025.
My lord, the affidavit of service of the
Let the affidavit of service file be kept with the record.
Number 49, Chandra Prakash Agarwal.
I appear for the plaintiff petitioner. My lord, there was a receiver appointed in this matter, my lord, to carry out an inspection of who is, my lord, who is in charge of the KMs, my lord, in charge of the electricity and who is taking control of that at this point. Yes, my lord. My lord, this is an application for receiver for administration. It is for hearing of that, my lord. However, there was one receiver appointed in that matter.
But I am the receiver appointed in the matter. If my lord kindly takes that order, may I indicate, my lord? There is a direction upon all the parties for the purposes of, kindly does not take me amiss, my lord, but there is a direction upon parties for the purposes of payment of remuneration and then for the purposes of conducting a surprise inspection.
Okay, let me see the order.
If my lord
The
kindly
last
takes
order.
the order dated, my lord, 21st of May 2024.
When was the order passed?
21st of May 2024.
So there was a direction to pay the receiver before
Yes, my lord.
vacation.
Yes.
Very well, definitely, if not before vacation, at least on the reopening date of vacation.
There was
Lord,
one.
this is last vacation.
My lord, there was.
Yes, I know, that is 2024.
There was one
May I-
discrepancy in the order, my lord.
May I
Please.
just indicate one thing, my lord? 75,000 divided 4 ways. That was the understanding between the parties. If my lord kindly comes to the order.
No, 75 joint fund.
Yes, there is no joint
There
fund.
is no joint fund.
The defendant number one, which my learned friend is representing, has paid his share to me. Now I am stuck in limbo, whether to or not to do the inspection. And thereafter, the matter is appearing for the first time yesterday.
So how many parties are there?
My lord, 4 parties.
So let it be shared equally.
My lord, that is fine, my lord. We are ready to do that, my lord. However, my defendant.
How much you have paid?
17,500.
My instructions are that the parties are in talks of settlement.
Very well, comply this order. Let them comply the order, because receiver is discharging the function. Why?
Kindly, my lord, either allow me to discharge the function or discharge me.
Learned advocate for the plaintiff and learned advocate for, yes, defendant number?
One. Number one.
Defendant number 1. Yes, you are appearing for?
My lord,
okay. Learned advocate for the plaintiff and learned advocate for the defendant number 1 are present.
Well, let it be out of that we have paid our share of fees.
Okay, learned receiver is present in court. It is submitted by learned advocate for the defendant number 1 that in terms of order dated 21st May 2024, the defendant number 1 has paid his share of remuneration to the receiver, learned receiver, amounting to rupees 17,500. Stop. It is further submitted by the learned advocates that as there is no joint fund from which the receiver's remuneration is to be paid, it is to be shared by the parties equally. Stop.
My lord,
The facts and
my lord, I may interrupt, my lord.
Yes.
There is my lord, I've been informed right now, my lord, there is a certain mistake that has been made, my lord, by me as well.
Yes.
My lord, the application appearing today, my lord, is GA8 of 2023 and
Yes.
not GA7 of 2023.
GA7 is appearing today.
No, my lord.
Only GA.
My lord, GA8 was an application under Order 39, Rule 2A.
Anyway, so GA7 be treated in the days list.
Very well, my lord. GA.
সবার উপরে একটু করে দেবেন, হ্যাঁ। GA7 is treated in the days list. আচ্ছা, তারপরে যেখানে বললাম, so
2023.
in the facts and
February 2020.
circumstances, the plaintiff and defendant number 1 and 2 are directed to pay their shares of remuneration to the receiver on or before 31st May.
Not ill possible. Kindly does
31st,
not.
yes,
Kindly does not take me amiss. It'll possibly be the plaintiff, the defendant number 2 and 3.
by the plaintiff,
is a
defendant
performance.
number, is the share of the defendant number 2, defendant number 3, and the plaintiff are directed to pay the share of, and the plaintiff are directed to pay their share of the receiver's remuneration by 31st May 2025.
That is only for defendant number 2 and 3.
Yes, defendant 2 and 3 and the plaintiff.
Yes.
The learned receiver shall thereafter take all necessary steps to act necessary steps in terms of order dated 21st May 2024. So please do the needful.
Yes,
My lord, if GA8 may be fixed for hearing as well, my lord,
Okay.
after the vacation, if my lord takes it,
Let this matter, let this GA7 of 2023 appear along with GA8 of 2023
23, my lord. Yes, my lord.
on 11/6/2025.
My lord, one request, my lord, on behalf of the receiver also, my lord, the payment, if it is to be made within 31st of
31st of May.
my lord, let him carry out his, my lord, the duties after the vacation, my lord, if that may be fixed right after the vacation, since, my lord, he
No,
may have.
I'm granting you the liberty to do the needful on or before 31st of May. They will do the needful on or before 31st of May.
I shall carry it out right after.
Grateful, my lord.
The matter will appear on 11/6/2025.
Grateful, my lord. Thank you.
2 and 3 and the plaintiff.
Extremely obliged.
For framing of issue.
Yes.
My lord, I'm appearing for the defendant
I'm
in the
appearing for the
matter.
plaintiff in this matter, Your
The
Lordship.
suit is for eviction. Both the parties had submitted the respective suggested issues. The suggested issues are before your lordship. We have considered on the last occasion, I took time because they handed it over in court and the matter was made returnable today. Now your lordship will kindly take up the suggested issues of the plaintiff, which was handed over last day, and prior to that, the suggested issues of the defendant as well. With regard to the suggested issues, my lord will have to take up both simultaneously. The suggested issues of the defendant, জজসাহেব কে দিয়েছেন? Defendant is suggested. Defendant টা তো নেই, আগেই দেওয়া ছিল। অত তলায় হবে না তো। আছে extra? My lord, it seems as if it's not there. We had filed it in court and we had also given them
Should
an
we have a
advance
copy of their suggested?
You have gone through the suggested issues.
Yes, we are
So you want to
defended.
submit anything on the
No,
both
which-
parties are required to submit
Lordship,
anything.
in essence, there are some issues which are common, although the language is different.
Apart from that, my lord, so far as the issues which were handed over by the defendant, issue number 1, 2, 4, 5, 6, 7, and 8 ought to be there. Along with that, whatever issues your lordship is keen on
7
taking
and 8. Where is 7 and 8?
my lord is probably not looking at
Plaintiffs,
the I am referring to the suggested issues by the defendant, but your lordship's court officers can't find it on record. It was filed prior to them, in fact, a day.
How many issues you have suggested?
Lordship,
6.
we have suggested 6 issues, Your
He
Lordship.
had suggested 8 issues. So far as my issues are concerned, my lord,
I have it in soft copy. I don't have an extra copy. Do you have an extra copy? No. I don't think so. Do you have an extra copy? Fine.
Okay, come tomorrow then.
My lord, can I hand up to your lordship?
Come tomorrow with a hard copy. Or on Monday
Yes,
with a hard
Monday
copy.
to do that. My lord, instead of tomorrow, then could
Monday.
Monday.
Lordship, Monday it's fine for us.
Yes, let this matter. Learned advocates for the parties are present. Let this matter appear on 19/5/2025 under the same heading. এটা একটু দেখে রাখবেন ওটা কপিটা সাজেস্টেড ইস্যু
My lord, it would be the month of April, and an order was also recorded by your lordship when we handed it over to your lordship.
Yes, I know. এই ওই
I was
suggested
appearing
issue টা
virtually
দেখবেন
that day.
কোথায় আছে।
My junior was there in court. He handed it over.
হ্যাঁ?
রেকর্ডে থাকা উচিত। না না এই কোর্টেই ফাইল হয়েছে।
হ্যাঁ, অর্ডার রেকর্ড হয়েছিল। দেখুন এটা এপ্রিলে।
80
Anyway, it will appear on Monday.
Monday, and I'll bring again the suggested
Yes.
issues of the defense.
হ্যাঁ,
My lord, I'm told that even affidavit of admission denial was also filed on that day.
So definitely
And
they must be in
order
the
was
record.
recorded. It should be on
You
the
may
record.
inspect the records after court hours.
Yes.
হ্যাঁ।
পেয়েছেন? দেখুন ওখানেই হবে। এপ্রিলের অর্ডারে রেকর্ডে থাকবে দেখুন।
Okay, it is recorded that suggested issues filed on behalf of the plaintiff be kept on the
That is
record.
the previous day, my lord, and
It is May 6, 2025.
yes, we had submitted in April. April order would be there.
April order. 15th April.
Could be because it was just prior to the hearing of May.
15th May. 15th April. Oh, this division bench. 15. नहीं तो May मास. अच्छा.
April order.
No, আমাদের 20th January তারপর 20
No, on April 17, it was recorded that suggested issues already been prepared. Okay.
Yes. And we
And let suggested
over.
issues be
Yes.
exchanged.
Yes. And also the admission denial we had submitted in
No,
court.
that was prior to that.
Yes.
And on May 6, it is recorded suggested issues filed on behalf of the plaintiff.
Plaintiff.
Anyway, you file it on the next day,
Yes, but
on Monday.
Original affidavit of admission and denial, if
No,
it is
that
not
must be here.
record, then
Definitely
again,
that has to be here.
we'll check with the record.
Yes. Check the records.
Grateful, Judge. 9
28, 29, 30, I received both the judgments relied by plaintiff and the non-suits.
ওটা রেকর্ডে রেখে দেবেন যেটা সিএবি হলো। Yes, call the last matter.
Grateful, Lordship. Witness action, item number 54, HON'BLE Jala.
Your Lordship, I'm appearing on behalf of the plaintiff. I'm seeking an adjournment. May this,
Please fix for plaintiff's witness evidence.
Your Lordship, kindly keeps it after vacation, Your Lordship.
Yes, recorder.
The defendant, Your Lordship, in this matter.
Learned advocates for the parties are present. On prayer of learned advocate for the plaintiff, the matter stands adjourned till 23/4/2025. I am fixing the time also.
Your Lordship, kindly.
3 p.m.
Your Lordship,
So bring your witness on that day.
I will, Your Lordship. I'm so grateful.
23/6/2025 at 3 p.m. Yes.
Lordship, item number 42, my lord. It's
40?
42, my lord.
Yes.
I missed the matter, Lordship. Can it be taken up, my lord? It's an application for substitution, my lord. J18.
So I've just made it not today, probably. But
Lordship,
today I made it not today. You come tomorrow. Service is complete upon the.
Yes. The appearing parties have all been served.
Okay, I shall take it up tomorrow. Hey, এটাকে 42 টাকে let this matter appear. Item 42 let ওই প্রথম 10টা ম্যাটারের মধ্যে দিয়ে দেবেন। হ্যাঁ। ওই তাহলে অর্ডারের মধ্যে আচ্ছা ওই অর্ডারটাকে কেটে দিন। ওই যেটা 42 তে নট টুডে করেছি তো ওটাকে জাস্ট লিখে দিন তো 42 তে যে learned advocate for the plaintiff is present, let this matter appear within first 10 matters on, I'm keeping it on Monday better.
Lordship.
First 10 matters on 21/5/2025.
I'm grateful, Lordship.
এটা কবে হলো গো?